My lord, may I be permitted to mention, my lord, one application for substitution in your lordship. This application
Yes.
of substitution, setting aside amendment.
Application for restoration.
May I be permitted to mention item number 55 of today's list, my lord? This matter, my lord was pleased to grant stay and direct me to deposit the awarded amount, my lord. Due to some technical issues, the deposit was deposited in the department concerned of the High Court, but beyond time, my lord. If my lord kindly keeps it to be mentioned or fixes at
Item number
55 of today's list, my lord.
55.
Or kindly keeps it at 2 p.m. so that I can show your lordship the
No,
slip.
2 p.m. I have other determinations. Come on tomorrow?
My lord.
Tomorrow 2 mention?
Deeply obliged.
Item number 55 tomorrow.
One and two already been disposed of. The calculation which are placed, well, as by some amount 50%, maybe not deducted. It can be deducted. That amount will be deducted. Consider one thing. One of the claimant, one of the deceased, the receipt, Bamun party, but it's wrongly said Bamun. So to kind of correct the same receipt, I filed an application to that extent and if those documents which I will give at the
Now, what is your first submission?
As submission is receipt, the claimants of by particular honor course order, withdrawal 50% amount will be withdrawn. That amount of perhaps not deducted as I place the calculation. So that amount will be deducted and the landed general will because to allow the claimants to withdraw the entire award amount along with the equity interest thereof, as well as the enhanced amount along with 6% interest after depositing the same, the landed general.
Yes, the claimant has already received 9,71,000. 331.99 paisa. Yes.
That is that can be taken note of that and proceed. The risk amount has already been enhanced by your lordship. That amount will be deposited by the insurance company, the landed general. And the after this will be allow the risk amount as they already deposited in support of their appeal on the time of stay application. So that has to be allowed to withdraw along with that. What the reason?
Before it has come up at my instance, lordship
Yes.
remembers. That is not the reason. Anyway.
Third is that the Bamun says is Bamun Pasi to be Babun Pasi. That I have filed an application for recording intermediate only that correction is Babun Pasi. I'll annex the admit card.
Have you filed the application?
Yes, Lord. I filed that. Application can 6 of 2002.
And 6 is pending.
If you have already attained majority, you will also can attend along this application. And only correction, Bamo should be Babo. And it's the P.
Babon Pasi.
Yes, it's Bamo to Bamo. And admitted
There. Yes,
Yes.
madam, you are, want to
Lordship,
submit
yes,
something?
yes. My lord remembers, Lordship, when this matter was taken up day before yesterday, Lordship. I was of the notion, Lordship, rather I was having the notion that since his cross goes, so award would not be enhanced, in my opinion, Lordship. So, but then it was enhanced, and I asked my Lordship that my lord is enhancing the award in
Yes.
my opinion. Lordship remembers, yes. Just on the academic.
I assess the
Yes.
just and proper
Yes, yes,
compensation.
my lord, yes,
Thereafter,
yes.
your argument starts.
Yes,
So
Lordship.
what do you want to
So
argue?
just one, two things, Lordship, regarding this cross objection, Lordship. I'll just pray for one liberty, Lordship. Only, Lordship will kindly allow my senior Mr.
Yes,
Singh
I
to
said
submit,
allow
because
now.
this is an academic issue, and only on this point, this whether award can be enhanced without the cross objection. Lordship, on this point, Lordship will kindly allow him.
Okay, on that
And
point you
on-
want to argue.
Let him
Very-
argue. And this is the
Lordship also after the hearing, Lordship dictated the judgment. So already matter disposed of. There is some clarification which I have mentioned. After the disposal, they cannot place any compilation or take issue. If they
No,
want to raise
if the,
issue,
if the insurance company was allowed to permit some, address some argument, so you may address, they may address.
If it's academical, if it's academical, then I have no objection. But it should not.
You have to take part,
But
you have to take part on such
that
argument.
cannot be judicial. That is my objection. If it's academical, then I have no objection.
Let me hear the matter. Let me hear the matter
And Lordship,
from you also.
Measure, after that, if they place any judgment of the Supreme Court, then Lordship can allow. Because prior to
No,
the
they
Supreme
let them argue. Why are you arguing?
Yes, Lordship, suddenly they will argue because they said academically, so they can enter the day for academic discussion.
Yes, only the matter of law is there, no issue.
Only
Yes.
because of Lordship, the Sundip measure on this that has been passed. That passed that. After dismissal cross objection, admitted. If they shown any judgment passed by the Supreme Court by the contrary judgment by the Sundip Juneja, then Lordship can allow. Or the judgment be placed by the Honorable High Court, or the award decision bench or the Honorable High Court, Calcutta High Court, decide the issue, but the Sundip Juneja was not there. If it's not there, or Lordship also consider.
Let them argue first, thereafter you have the opportunity to answer.
Answer, but Lordship kindly for judicial hours, Lordship. But Lordship, if they place any judgment after by dealing with the judgment of Sundip Juneja, then I have no objection.
No, whether you want to take part of this argument or not.
Lordship, after disposal,
You not know. Very well. I can hear the insurance company
This
also.
is the compilation,
No.
Lordship. I just a copy.
Yes, Mr. Singh, you can argue.
This is one copy.
I'm grateful to your lordship.
Yes.
and Lordship, if he agrees to judgment of Lordship, then we will fight there is the proceedings. They should come with the proceedings, Lordship. I believe that should not be permitted. On academic research, and Lordship will allow him. Also, Lordship will allow him.
No, I am hearing on the merit of this case. I am hearing on the merit of this case.
After the judgment.
No, after the judgment was passed, the matter was not signed. It was.
Sign is the issue. Lordship knows the.
No. You have also mentioned the matter before the chamber that some correction is there.
That I can.
So that's why I not signed the matter.
That arithmetical mistake.
No. Then also you have to file a review. If the truly strictly in legal term. But what prevented you to take part in the argument? Come on, take part with the argument. Let's settle the issue first. What is the dispute? You are also a senior advocate. Mr. Singh is there. Let the matter be settled. Why there is such a luka-chupi like that? Okay, let's start.
No, I don't.
Okay.
No, I don't think.
Okay, no
I'm
idea.
very fair.
Very well.
Very fair.
Let's start. Everyone is knowledge of law is required. Let's start, Mr.
I'm
Mr.
deeply
Singh.
blessed, my lord. My lord, the point on the last day when the matter was taken up by your lordship, my lord, and your lordship was delivering the judgment, my lord, I was in the court. Lord, my learned junior, my lord, it was an impression that since your lordship is, my lord, it was already submitted before your lordship, that since my lord is not taking note of the cross objection, so my lord, in absence of cross objection, my lord, there would not be any enhancement. My lord, that notion that in absence of any cross objection, my lord, the compensation would not be enhanced, my lord, was based on a couple of judgments passed by your lordship, wherein, my lord, your lordship, while assessing the just compensation, when there was no cross, my lord did not enhance the compensation. My lord, at least I am aware of 2 of those judgments passed by your lordship. So, my lord, under that notion, my lord, that the compensation would not be enhanced, my lord, the argument was concluded. But, my lord, at the very last, my lord, the statement of your lordship, my lord, wherein my lord said that yes, I am enhancing in view of plan SAT. And then, my lord, my lord, still got up and asked your lordship, my lord, is still, my lord, enhancing the compensation. Your lordship said that in affirmative. So, my lord, that was, my lord, the wrong idea, my lord, on our side. I admit that, my lord, we were not aware. My lord, we thought, my lord, once the cross goes, my lord, the enhancement also goes.
Yes.
So, on that basis, my lord, the matter was brought to my lord's notice, my lord, yesterday. Your lordship was kind enough, my lord, to allow us to, my lord, place further arguments on this. My lord, as my lord had directed, my lord, we had prepared, my lord, this is a small paper book in which is compilation of cases, my lord. One is before your lordship, my lord, one I have given to my learned friend, my lord. Lord, I would only, my lord, deal on this issue, my lord. I am not getting into the merits of the case. I am not getting into the facts of the
Yes,
case, my lord. I am not interested. I am not
nothing.
concerned. Only, my lord, this point of cross objection.
Yes.
My lord, I had, my lord, in other.
Only the issue is that when there is no appeal or cross objection filed on behalf of the claimant,
My lord.
in the appeal of insurance company, if it appears there is a just and proper compensation was not awarded by the tribunal, whether it can be awarded in the appeal. This is the only question.
I am deeply obliged, your lordship.
Yes.
I am grateful to you.
This is the only question
I am grateful.
that has to be discussed to settle the issue.
এটা আমার পুস্তকটা দেখুন। আপনি আমি mark করেছিলাম না? My lord, the first one. My lord, first of all, my lord, I'll take your lordship, my lord, to the division bench judgment of this honorable court. The bench headed by Honorable Justice, my lord, Dipankar Datta,
Yes.
as his lordship then was. And then, my lord, I'll come to your lordship, my lord, on the judgments which were relied upon by his lordship, my lord, so that it becomes easier to your lordship. My lord, kindly, your lordship, my lord, will come to page number 9 of this. My lord, is at page number 9, my lord?
Shulaka Das.
Lordship, I'm grateful to your lordship. My lord, one thing I indicate to your lordship, my lord, this your lordship will kindly see, it was heard on August 1st, July 25th and August 1st. My lord, there were other dates also. My lord, judgment was delivered on November 22nd.
Yes.
My lord, there is a reason, my lord, why I indicated to your lordship. Because, my lord, Puja vacation went in between. Entire August went, September went. After the reopening of the court, my lord, on November 22, not much later, this judgment was delivered. And my lord, in even open court, on a number of occasions, my lord, Honorable Justice Datta, my lord, my learned friend was there in this matter. My lord, he spoke that my lord, Honorable Court has given, my lord, much thought to this judgment. He has given a lot of effort. That is why, my lord, it took so much of time. My lord, that was in open court. My lord, there is no secrecy to this. Why I say this to your lordship, my lord, their lordships, my lord, had taken a lot of pain in delivering this judgment, wherein this, my lord, Order 41 has been dealt with extensively. But I'll just, my lord, not getting into the facts. This is the appeal of insurance company. Compensation was assessed. Insurance company preferred this appeal. There was no cross objection, my lord. And on that basis, my lord, Honorable Court, my lord, wanted to enhance the compensation. My lord, I took the specific plea, my lord, in absence of cross objection. Or, my lord, in view of the judgments of Ranjana Prakash, my lord has already seen Ranjana Prakash, and there was one more, Swaminathan, my lord, which way specifically under Motor Vehicles Act, your lordships, my lord, should not increase the quantum of compensation in my appeal. This was a specific plea. Their lordships, my lord, ultimately, even though mentally their lordships were not in my favor, but still, my lord, their lordships restricted. They were magnanimous enough, my lord, to concede to the fact that in 2 other cases earlier, wherein I was not there, my lord, some of my learned friends argued the case, their lordships has increased the compensation. Their lordships, my lord, as I said, my lord, they were magnanimous enough to concede to said fact that these judgments or these facts were not brought to our notice earlier.
So those two judgments, what I had given earlier, what we had given earlier, it was a division bench, my lord, was, my lord, incorrect. So their lordship, my lord, went to that extent of admitting the case.
Yes.
After taking note of pranayasati. But now, my lord, I'll show it to your lordship. My lord, your lordship will kindly come, my lord, to the paragraph 11. I'm sorry, my lord, page number 11. Last third, fourth line, my lord.
Yes.
It was observed, last sixth line, it was observed that the claimants are entitled to rupees 23 lakhs odd on account of compensation. My lord, this 23 lakhs, last fifth line, my lord, was the compensation amount. Page number 12. My lord, I'll just come to the relevant part so that, my lord, I will not trouble your lordship much. Page number 12, paragraph 4. The prayer of insurance company, my lord.
Yes.
Paragraph 4, it was accordingly prayed that award be set aside and the appellant absolved of his liability to compensate the claimant. That was the prayer, my lord. Insurance
Yes.
company's prayer before the appellate court. Paragraph 5, my lord. Answering the contentions raised in support of the appeal, Mr. Counsel, learned advocate for the claimant, submitted that absolutely no case for interference in the exercise of appellate powers had been set up. On the contrary, claimants are entitled to higher amount of compensation, which they are entitled in law to claim even without filing a memorandum of cross objection.
Yes.
My lord, this is a specific case, my lord, this is a specific point, specifically taken, the same thing what we are arguing before your lordship. My lord, lordship will kindly come, my lord, page number 14. Skipping, my lord, your lordship, kindly pardon, my lord, I will not trouble your lordship with those. Page number 14, paragraph 10.
Yes.
It was further contended by Mr. Counsel that the tribunal fell in error in not awarding any interest on the assessed compensation from the date of filing of the claim application. According to him, no reason was assigned by the tribunal why it considered the claimants not entitled to interest from such date and awarding interest only on default of the appellant to pay compensation within the date as specified. 11. Also relying heavily on the decision in Rajesh Rajbir, Mr. So-and-so contended that even in respect of claim application arising out of death of a clerk in a motor accident in 2007, Supreme Court awarded rupees 1 lakh towards consortium, 1 lakh towards loss of care, and 3 minor children, 25,000 on account of funeral expenses. Para 12. At this stage, Mr. So-and-so submitted that the appellant cannot be worse off. Now, this is the argument. Appellant cannot be worse off for presenting this appeal, and he prayed for liberty to cite an authority for the proposition that in the absence of a cross objection, the High Court in an appeal under section 173, which is filed by the owner or insurance company for reducing compensation, cannot increase compensation over and above what is awarded by the claims tribunal. But this is exactly what we are praying before your lordship.
Yes.
Fifth, 13, my lord, paragraph. Availing the liberty granted by us, Mr. So-and-so cited the decisions of Supreme Court in the case of Ranjana and Swaminathan and unreported decisions of Madras, Andhra, Karnataka, so-and-so. Lord, I'll not take your lordship, Lord, the trouble of this Andhra, Karnataka, and Madras. Paragraph 14. Per contra, Mr. Counsel referred to the provisions of Order 41, Rule 33 of the CPC and contended that the wide-ranging power conferred on an appellate court thereby would bestow on the high courts exercising appellate power the authority to award higher compensation in a given case, where the claims tribunal is found to have committed glaring mistakes in computing notional income, selecting the appropriate multiplier, not awarding interest without any cause, etc. To buttress this contention, Mr. Counsel placed reliance on the decision of Supreme Court in this case of Pannalal, Mahant Dhangir, Delhi Electric Supply Undertaking, Ravi Kumar, Sona Babu, and the decisions of this court in Vijay Kumar Chakraborty, the Odisha High Court in New India, and the Bombay High Court in the state of Maharashtra.
Yes.
It is now time for us, my lord, to consider the rival contentions and render our decision on each one of them. My lord, kindly come, my lord, to page number 21. My lord, I must also indicate to your lordship, my lord, before I proceed further, when the hearing was concluded, Pranay Sethi was not there. But what was there? Starting from Sarla Verma, Santosh Devi, Reshma Kumari, 3 judges bench, Rajesh Rajbir, 3 judges bench, those all were there. Those all specifically stated when a future prospect has to be granted? What is the mode of this deduction? What should be the appropriate multiplier, which is Sarla Verma there? Why Pranay Sethi came into existence? That also, I'll just take 1 minute to tell your lordship. Sarla Verma, being the mother judgment, what we call, decided these issues of computation in a particular manner. Therein it is stated, this is the way future prospect should be calculated, amongst others. This was referred by another division bench, Santosh Devi. They said, no, something more is to be granted. Sarla Verma division bench was affirmed by Reshama Kumari, 3 judges bench. This chain goes. Santosh Devi division bench, which differed a little from Sarla Verma, was affirmed by another 3 judges bench, Rajesh Rajveer. So, now there were 2 division benches, Sarla versus Santosh, and then, on the upper echelon, it was Reshma versus Rajesh. In view of these contradictions, in one case, Pushpa, the matter was referred before Honorable Supreme Court for constitution of larger bench. That is how Pranay Sethi came into existence.
Yes.
Only to decide this issue, whether this particular chain of thoughts is correct or this particular chain of thought is correct. And then, this Honorable Supreme Court, relying heavily on Sarla Verma and tweaking a little here and there, came to the conclusion that, well, this should be the mode of computation. So that was the referral bench in view of the conflict of 3 judges bench. These 3 judges bench and these 2 division benches were already in existence when these matters were taken up. Only the Pranay Sethi came during this pendency when the judgment was being delivered. I'm obliged to Lordship. Paragraph 29.
Yes.
Reliance placed on Rajesh by Mr. Counsel was apt. As on date, we had reserved judgment on this appeal. If the tribunal had the benefit of looking into such decision, which was rendered nearly 5 months before the award, and the challenge came into existence, the compensation awarded to the claimants could have been on the higher side. It's noticed that the learned advocate for the claimants failed to place such decision before the tribunal, for which the tribunal cannot be faulted. We also hasten to record that the Constitution Bench of the Supreme Court in a recent decision dated so-and-so, National versus Pranay Sethi. So, it is already taken on record, everything considered. It cannot be said that their lordships were oblivious, even just because it was not argued.
Yes.
Pranay Sethi has held the law laid down in Rajesh not to be a binding precedent. However, having regard to the conclusions recorded in paragraph 61 thereof, the claimants could claim enhanced compensation under the heads of future prospect, loss of estate, loss of consortium, and funeral expenses over and above what the tribunal awarded in their favor. Specifically, every single aspect of Pranay Sethi has been recorded here. What Pranay Sethi said and what one should be made entitled to, their lordships have taken note of, not only taken note of, they have recorded in the judgment.
Yes.
Argued or not argued. 30 minutes. At this juncture, it's necessary for us to consider the provisions of Order 11, Rule 33 of CPC and decide whether, in absence of any cross objection from the side of the claimants, they are entitled to any sum on account of interest or higher sums as determined in Pranay Sethi. Again, your lordship will kindly listen. For the facility of the reference, it is quoted below. The section order has been quoted, 33. Order 41, Rule 33 quoted. I'll not trouble your lordship with those the specific wordings of this order. Page number 24. Paragraph 34. Before that, certain cases were referred to, which have been dealt with in paragraph page number 23. Page 24. These cases were referred to by Mr. Roy Miller. There. Page 24, paragraph 34. However, it is noted that none of these cases arose out of application under the Act. The Act means under the Motor Vehicles Act. The fact situations were also entirely different from the one of which we are in session. 35. The reasons cited by Mr. So-and-so relate to claim applications under the Act and thus would have a bearing on the issue presently under consideration. 36. We may first look at the decision in Ranjana. The facts and the contentions raised by the parties have been noted in paragraph 2 to 4 of the decision. Concerned tribunal awarded a compensation sum of rupees 24 lakhs with interest 9% in favor of the claimants. On appeal of the insurer, High Court, while upholding the findings in regard to income and calculation of compensation, held that claims tribunal ought to have deducted 30% of the annual income towards income tax. Consequently, High Court deducted 30% and reduced the compensation to 16 lakhs odd, with interest 9%. The said order was under challenge before the Supreme Court at the instance of the claimants. Your Lordship will kindly take note, my lord. In High Court, there was no challenge by the claimants. It was the appeal of the insurance company. In Supreme Court, my lord, the claimants contended that the High Court committed an error in reducing compensation from 24 lakhs to 16 lakhs and sought restoration of the compensation as awarded by the claims tribunal. Before the High Court, the insurer contended that where the annual income of the deceased was in a taxable range, the annual income for the purpose of computation of compensation should be the annual income less income tax, and that in the absence of any evidence as to the actual income tax paid, the claims tribunal ought to have deducted 30% from the income towards income tax and calculated the loss of dependency with reference to the net income. The claimants, on the other hand, contended before the High Court that as the deceased was holding a permanent job under a statutory body with assured increments and career progression and was aged between so and so years, as per the decision of Sarla Verma, the income ought to have been increased by 30%, keeping the future prospect in view. They further contended that if the income has been increased by 30% by taking note of future prospects, and if 30% has been deducted towards income tax, that would virtually leave the income assessed by the claims tribunal undisturbed, and therefore computation of 24 lakhs, monthly income of 23,000 odd, as decided by the claim tribunal, without any deduction, did not call for any interference. It was on consideration of the aforesaid contention that the Supreme Court proceeded to hold. Now, my lord, what the Ranjana Prakash is stated, that is quoted. Therefore, in an appeal by the owner insurer, the appellant can certainly put forth a contention that if 30% is to be deducted from the income for whatsoever reason, 30% should also be added towards future prospect so that the compensation awarded is not reduced. The fact that the claimants did not independently challenge the award will not therefore come in the way of their defending the compensation awarded on other grounds. It would only mean that in an appeal by the owner insurer, the claimants will not be entitled to seek enhancement of the compensation by urging any new ground in the absence of any cross appeal or cross objections. This is not what their lordships have underlined. Taking note of this. My lord, whatever the award has been passed, up to that it is okay. You fight it out with your teeth. But claiming enhancement, that Supreme Court said, my lord, is not permissible.
Yes.
You cannot piggyback on somebody else without your effort. And then you say that, no, I'm entitled for something more. My lord, it further goes on to say, paragraph 7, my lord, the principle also flows from an order 41 rule 33 of the CPC, which enables an appellate court to pass any order which ought to have been passed by the trial court and to make such further or other order as the case may require, even if the respondent had not filed any appeal or cross objections. The power is entrusted to the appellate court to enable it to do complete justice between the parties. Order 4133 of the CPC of the court can, however, be pressed into service to make the award more effective or maintain the award on other grounds or to make other parties to litigation to share the benefits or the liability, but cannot be invoked to get a larger or higher relief. For example, where the claimants seek compensation against the owner and the insurer of the vehicle, and the tribunal makes the award only against the owner. On an appeal by the owner challenging the quantum, the appellate court can make the insurer jointly and severally liable to pay the compensation along with the owner, even though the claimants had not challenged the non-grant of relief against the insurer. Be that as it may. Now, my lord, again, this paragraph 8. Where an appeal is filed challenging the quantum of compensation, irrespective of who files the appeal, the appropriate course for the High Court is to examine the facts and by applying the relevant principles, determine the just compensation. If the compensation determined by it is higher than the compensation awarded by the tribunal, the High Court will allow the appeal if it is by the claimants and dismiss the appeal if it is by the owner insurer. Your lordship, this is very important. I'll just reread this line. If the compensation determined by it is higher than the compensation awarded by the tribunal, the High Court will allow the appeal if it is by the claimants. Not claimants appeal, if they ask for the higher compensation, is to be allowed, and dismiss the appeal if it is by the owner insurer.
Yes.
Similarly, if the compensation determined by the High Court is lesser than the compensation awarded by the tribunal, the High Court will dismiss any appeal by the claimants for enhancement but allow any appeal by the owner insurer for reduction. The underlined part again done by their lordships. The High Court cannot obviously increase the compensation in an appeal by the owner insurer for reducing the compensation, nor can it reduce the compensation in an appeal by the claimants seeking enhancement of compensation.
Yes.
My lord, pausing here for a moment. Your lordship kindly remembers, my lord, yesterday I put forth this argument. One of my learned friends' appeal was there. And I specifically, my lord, took plea of this. In their appeal, they are asking for enhancement. And if my lord finds that whatever amount they have got, let's say X amount, they were not entitled for that X, would it be my lord's pleasure to say that it would be half X and you return half X to the insurance company in their appeal? This is where the dichotomy is. This is where, my lord, the complexity arises. That's what the Honorable Supreme Court said, that no, you don't do it. So in spite of my argument yesterday, I would not be entitled to refund, because I cannot piggyback on claimant's appeal. I did not come up with a separate appeal. I was happy with the award. There is no cross objection. I cannot take advantage that you came to the court for relief, and in your prayer of relief, I will get in and I will say, no, whatever you've got, you will not even get that. My argument on this legal parlance yesterday, what I made, that was incorrect.
Yes.
And this is not exactly what I was praying. And this is what the Supreme Court has said. My lord, 37. In Swaminathan, the claimant approached the claims tribunal seeking 10 lakhs for injuries. The claims tribunal awarded compensation of rupees 4.5 lakhs. Appeal was presented by the insurer before the single bench of High Court. Appeal was allowed. Compensation reduced to 3 lakhs. Not in the appeal of insurance company.
Yes.
On letters patent appeal, division bench of High Court enhanced the compensation to rupees 744 to the claimant. For such enhancement, division bench assigned the following reason. In this connection, we may observe that we are aware of the fact that we are enhancing the compensation even though the injured had not claimed it. But the question is covered by catena of decisions justifying enhancement of compensation even in cases where the injured has not preferred an appeal, provided the circumstances of the case warrants the same.
Yes.
The decision of division bench of High Court was under challenge before the Supreme Court. My lord, appeal of insurance company, award reduced. Lordship will kindly remember the fact. Appeal of insurance company, award reduced. Claimant did nothing. Claimant preferred an appeal. Against, my lord, single bench, it went to the division bench. Let us speculate. Appeal court enhanced the award. What this honorable single bench had granted. Supreme Court said that no. When the claimant was happy with 4 lakh of, my lord, this 4.5 lakh, he did not come to the court. Then how come in the appellate forum, my lord, before the honorable division bench, this 3 lakh which was reduced, it can go to 7.44 lakhs. At the best, it can go up to 4.5 lakhs what he had got in the tribunal. But over and above, without his effort, without cross objection, or, my lord, without a separate appeal, he cannot go beyond 4.5 lakhs. This is what Swaminathan has said, my lord. The division bench, my lord, at page 27. The decision of division bench of the High Court was under challenge before the Supreme Court. The issue was whether the division bench of the High Court was justified in increasing the compensation amount beyond the amount awarded by the claims tribunal, despite the fact that its award had not been challenged by the claimant. The aforesaid reasoning of the division bench of the High Court was observed to be a very facile way of interfering with the award when no interference was called for. The court then proceeded to hold as follows. We called upon the learned counsel on both sides to show us at least one case out of the catena of judgments referred to in the impugned judgment in support of this proposition. Learned counsel frankly confessed that there was none. On the other hand, the learned counsel for the appellant drew our attention to the judgment of this court in Banarasi, which supposed the proposition that in an appeal filed by the defendant, laying challenge to the grant a smaller relief, the plaintiff as a respondent cannot seek a higher relief if he had not filed an appeal on his own or had not taken any gross objection. In the present appeal, it would appear that the claimant neither appealed against the award of compensation passed by the tribunal, nor filed any cross objection in the first appeal filed by the insurance company. This, we are satisfied the division bench of the High Court wholly erred in increasing the compensation amount beyond the amount awarded by the tribunal in the appeal filed by the insurance company.
Yes.
Millard, these two judgments, this Ranjana and Swaminathan of Honorable Supreme Court, Millard, I have annexed, Millard, as Millard, the first judgment and the second judgment in this compilation. Millard, specific paragraphs have been marked. I will not now trouble your lordship will again going back into those and Millard marking those two particular paragraphs which have been Millard quoted here and I have read before your lordship. Millard, that is only for my lord's convenience that those two judgments Millard I have already put in there.
Yes.
As number 1 and number 2. Millard, now I proceed further. Millard, 38, the Banarasi reference has been Millard dealt with, and Millard, the quotation part, Millard, is at page 28. Their lordships have again underlined. Page 28, Millard, Banarasi judgment, paragraph 22. For the foregoing reasons, we are of the opinion that the first appellate court ought not to have, while dismissing the appeals filed by the defendant appellant before it, modified the decree in favor of the respondent before it in the absence of cross appeal or cross objection. The interference by the first appellate court has reduced the appellants to a situation worse than in what they would have been if they had not appealed. The High Court ought to have noticed this position of law and should have interfered to correct the error of law committed by the first appellate court. My lord, this is of Banarsi, Pannala. My lord, next page is 29. Top 6 slide below there. My lord, the lordships have been dealing with my lord 4133. The scope. Page 29, my lord, the 6th line from the top. 1, 2, 3, 4, 5, 6. Yes, my lord. At the left, 6th line from the top, the essence of the decisions. My lord has got it, my lord?
Yes.
The essence of the decision cited by Mr. Counsel is that an appellant cannot be worse off for filing an appeal should there be no cross objection there against, and the award of claims tribunal attains finality on the claimant accepting the same without carrying it higher up. We have no option but to accept such position as the law governing even claim appeals under the Act, although we shall briefly indicate our view hereafter, which, though at variance, is of no consequence in view of Article 141 of the Constitution. Your lordship will kindly see, my lord. My lordship will kindly pardon me for reading it again. This is the view of their lordship. Their lordship is, my lord, as I stated earlier, were not happy while delivering this judgment. Not happy in the sense, my lord, their lordship said that maybe Plana Seti should prevail. But in view of 141, my lord, in view of the fact that the judgments of my lord Swaminathan and Ranjana Prakash are specifically under the Motor Vehicles Act, they have specifically dealt 4133. Everything taken note of, taken care of, dealt with, and then decided. That is where their lordships, my lord, as I said, my lord, restrained themselves. Yes. And said, my lord, even though we are unhappy, but in view of 141, we are unable to increase the quantum of compensation. And the reasons, my lord, have been again given subsequently. This is what, my lord, I said, the indication what their lordship had, my lord, in their mind. I will just read, my lord. We have no option but to accept such, I'm reading that, my lord, from the 10th page, 10th line. We have no option but to accept such position as the law governing even claim appeals under the Act, although we shall briefly indicate our view hereafter, which, though at variance, is of no consequence in view of Article 141 of the Constitution. Enhancement of compensation claimed by Mr. Counsel pressing into service Order 41, Rule 33 of the CPC may not, therefore, be a permissible course here in view of the decision in Swaminathan and Ranjana. My lord, paragraph 40.
Yes.
Having said so, it cannot be overlooked that the provisions of 4133 of CPC, although not part of the substantive law relating to appeals under section 96 and 100 of CPC, quite unusually confers wide powers on an appellate court. The marginal note of Rule 33 says power of Court of Appeal. The wide expanse of power conferred on a court of appeal authorizes it to pass or make such further or other decree or order as the case may require. Importantly, this power is available to be exercised by the court, notwithstanding that the appeal is as to part only of the decree and in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection. Underline for emphasis. Then paragraph 41. Again, my lord, their lordships had dealt with 4122 rule, order 41 rule 22. My lord, the sixth line of that paragraph, 1, 2, 3, 4, seventh line. My lord, seventh line from paragraph 41. The power conferred on a court of appeal by order 4133 is discretionary, and no relief thereunder can be claimed as of right, as can be claimed if a cross appeal or cross objection were filed. My lord, their lordships were not oblivious of the fact of just compensation. It was there in the mind. Paragraph 40 says, my lord, 42. We also need to bear in mind that the scheme for payment of compensation to the legal representatives of a victim of a motor accident or to a surviving victim is a beneficent piece of legislation. The object, therefore, is to ensure that they do receive just compensation. What is just compensation? We can do no better than reproduce below a passage from the decision of Supreme Court. In the case of my lord, Karnataka State versus Mahadeva Shetty, my lord, it speaks about that has been quoted. What is just, my lord? I will not trouble your lordship, because just, my lord, means it should be appropriate, it should be correct, it should be lawful, and it should not be a bonanza or a lottery.
Yes.
That also is made clear. My lord, thereafter, I would invite my lord to come to page number 34. Page number 34, my lord, is at the bottom is paragraph 46. Page 34.
Yes.
My lord, just, my lord, 4-5 lines above that. 46, my lord, paragraph 5 lines above that. In the middle, had it not been. My lord has got it, my lord?
Yes.
My lord, before this, my lord, 5-6 pages, what is just compensation? What should be awarded? Those have been dealt with. I'm not troubling your lordship. My lord, I'm starting with this had it. Had it not been for the decision in Ranjana and Swaminathan, we would have most certainly enhanced the compensation, an exercise of our appellate powers to provide just compensation to the claimants and thereby do complete justice between the parties, since, in our view, this is an exceptional case warranting such approach. Your lordship will see, my lord, what my lords were thinking. And then 46. We, however, part with the observation that unless the Supreme Court revisits the issue and reverses the ratio of decision in Swaminathan and Ranjana and lays down the law authoritatively for guidance of the high courts, thereby paving the way for award of enhanced compensation in course of appeal, proceeding without there being any cross objection. In exceptional cases warranting such approach, order 4133 cannot come to the rescue of the respondent's claimants for enhanced compensation in an appeal by the owner or the insurer for reducing the compensation awarded. This is the specific finding. Their lordships wanted, but their lordship said, in view of these restrictions, we cannot do. 47, is again important. We have enhanced compensation while deciding. This is what I was referring to. We had enhanced compensation in deciding this by judgment and order dated July 18, 2017. However, the decision was rendered without taking into consideration the decisions in Swaminathan. It is, and Ranjana, it is therefore a decision per incurium and does not deserve to be followed. Lordship will kindly see the magnanimity of the Hon'ble Court.
Yes.
Took note of the earlier judgment and not accepted that yes, it is per incurium. Because these facts were not placed, this argument was not made. I was not in that matter. Subsequently, I came to know about it. That is why, this was informed to their lordships, and their lordships recorded it in this judgment. 48. Insofar as the present exercise is concerned, we are unable to accept Mr. Counsel's contention and accordingly refrain from enhancing compensation. However, it is clear on reading of the discussion on the merits of the appeal that the impugned award does not merit interference. The purpose of compensation is to put the claimant in the same position as he was insofar as money can. But for the claimants here, it has been a far cry. Then the stay. This comes to an end.
Yes.
So now, this is the final wordings of their lordships. Take a note of every single aspect of the case. Take a note of every single judgment which was there available, at that point of time. And then thereafter, coming to conclusion that since Ranjana and Swaminathan were specifically on this Motor Vehicles Act, Honorable Supreme Court specifically dealt with those. 141 is binding, and in Motor Vehicles Act, note for the enhancement cannot be made. Taking note of prenacity.
Yes.
This was not challenged. This remains what it is. And thereafter, their lordships, in all other judgments, whatever they passed, their lordship discontinued. His lordship, Honorable Justice Dotto, continued with this motor vehicle bench for a very long time. And at that point of time, it was the division bench. Not even in one case, the compensation was enhanced without cross objection. Not tested, not challenged, and strictly followed. Prenacity was there. Now, the next is page 37. Honorable Justice Vibhas Ranjan De. I'll straightway, this is again the appeal of insurance company. I'll simply invite your lordship to page number 43. Page number 42 to be precise. Page 42, paragraph 10.
Yes.
Mr. Learned Advocate, Mr. So and so on behalf of the claimant. This is appeal of insurance company. During his argument at the initial stage, conceded the submissions made on behalf of the insurance company, and also submitted that insurance company may be directed to discharge its liability by paying rupees so and so with interest to the claimants. That was the initial submission. But at the time of parting with his argument, Mr. So and so, as he normally is, I would not make any comment. He refrained, and he all of a sudden advanced an alternative argument that give me just compensation. He referred to the decision of Supreme Court in Sureka. Paragraph 11. This is again following prenacity. On going to the decision of Sureka, I find that the claimants preferred appeal before the Honorable High Court. And after being denied, preferred the SLP before the claimants preferred SLP before the Honorable Supreme Court. Honorable Supreme Court determined the just compensation, unlike the case in my hand. Here in our case, claimants never preferred any appeal against the judgment and award passed by the learned tribunal. Likewise our case, Not only that, claimants never filed any cross objection. Also, after filing of the instant appeal by the insurance company, it appears from the record that claimants accepted the judgment and award passed by the tribunal and admittedly received rupees so and so, along with the interest of Oriental Insurance. Therefore, in my humble opinion, this court finds hardly any scope to consider the just compensation. So, that was not allowed. Whatever was, the award. The point is, no enhancement was made from the awarded sum. I argued this case. And there also, I gave this judgment of Sulekha Das and others, whatever there are. Because Sulekha Das, imbibes the other, Ranjana and Swami Nathan, those are already inbuilt there. This was at page number 46. This was the judgment passed by his lordship. My lord has seen that, other points were taken, I'm not on those, I will not have a lordship on those.
Yes.
I'm only, on this cross and not enhancement. Your lordship will kindly come, to page number 47. This is another case.
Yes.
Again, your lordship will kindly see, the trouble. Last hearing, 1st December 2022, judgment 10th April. Appeal of insurance company. My lord will kindly come, to page number 54. Various judgments have been cited. I'm not troubling a lordship with those. Page 54 is the relevant part. He means, the learned advocate for the claimant. He further submitted that the tribunal considered the income of the deceased 15,000, however, failed to take into account the additional income of 40% of annual income towards future prospect. As usual, claimants, this is the argument forwarded. And as such, the judgment award needs to be enhanced and modified to the above extent. Though the respondents' claimants did not file any cross appeal or enhancement yet, under Order 41 Rule 33, again, is coming to the picture, of the CPC, the appellate court has power to pass appropriate order, regardless of the fact that the appeal is only with respect to a part of the decree, or that appeal is filed only by some of the parties, and such provision is applicable, mutatis mutandis, to appeals preferred to a High Court under 173 of the Act as provided, under Rule 346, sub Rule 3 of the West Bengal Motor Vehicle Rules 89. Thus, Even if no cross appeal for enhancement has been filed or made by the respondent claimants, it does not debar the appellate court from enhancing compensation in an appropriate case. In this context, he has also referred to the following decisions of different high courts: National versus Milord this Karnataka, then there is one Madras, and then there is one Milord Delhi. Paragraph 10. Mr. So-and-so, learned advocate for the appellant, insurer, in reply to the proposition raised on behalf of the respondent claimants, that the award passed by the tribunal can be enhanced without there being any cross appeal for enhancement by them, submitted that as per the decision of Swaminathan, Ranjana Prakash, it is now settled proposition of law that there cannot be enhancement of compensation in an appeal filed by the insurance company without there being any cross appeal by the claimants for enhancement. He further submitted that following such proposition laid down by the Honorable Apex Court, the division bench of this Honorable Court in Sulekha Das, what I had read before your Lordship. While dealing with similar question, whether in the absence of any cross objection from the side of the claimants, they are entitled to enhancement by considering the provision of Order 41 Rule 33 of the CPC, held that an appellate court cannot be worse off for filing an appeal should there be no cross objection there against an award of the claims tribunal attains finality on claimant accepting the same without carrying it higher up.
Yes.
Thus, an argument advanced on behalf of the respondent claimant in this regard fall short of merit. Paragraph 11. Last second line, my lord. And lastly, my lord has got it, my lord. And lastly, whether in the absence of cross objection from the side of the claimants, they are entitled to enhancement of compensation invoking provision of so and so. Again, my lord, Order 41 Rule 33, Civil Procedure Code. It reaches its finality, my lord. All other things have been dealt with. Judgments which were referred to, my lord, they have been taken note of. And then, my lord, if I may kindly invite your lordship, my lord, at the very fag end of this judgment at page number 68.
Yes.
My lord has got it, my lord, page 68, the last paragraph at page, my lord, paragraph 15 at page 68. Paragraph
Yes.
15, my lord, is there. The last issue involved in the present appeal is whether in the absence of cross objection from the side of the claimants, they are entitled to enhancement of compensation invoking provisions of Order 4133 of CPC. Mr. So-and-so, advocate for the respondent claimant, submitted that the claimants are entitled to an additional amount of 40% on the annual income of the deceased victim towards future prospect. And the compensation amount requires to be enhanced, relying the division bench, different decisions to different high courts and also referring to the rules. He submitted that the compensation can be enhanced, taking recourse to the provision of the rules. Even in the absence of cross appeal, refuting such contention, Mr. Counsel, learned advocate for the appellant, relying upon, my lord, again, Swaminathan, Ranjana, Sulekha, submitted that compensation amount cannot be enhanced in absence of cross appeal filed by the claimants. 15.1. At the very outset, it is placed on record that the respondent claimants have not filed cross objection for enhancement of the compensation amount. For the convenience of the discussion of rule 3341 of CPC is reproduced here. It has been reproduced, page number 70. I am not continuing with the paragraph, the observation of the Honorable Court. The aforesaid provision deals with the power of the Court of Appeal to pass an appropriate order in the case regardless of the fact that the appeal is only with respect to a part of the decree or that the appeal is filed only by some of the parties, and such power may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection. Rule so-and-so of the West Bengal Motor Vehicle Rules makes the provisions of Order 41 of the CPC applicable to appeals referred to High Court under Section 173 of the MV Act. Now the question which requires consideration is whether the compensation amount can be enhanced in the absence of cross objection. The answer is, my lord, in 15.2, Swaminathan's case, Supreme Court negated the enhancement. My lord, I'm at page 70, my lord, I'm continuing. The Supreme Court negated the enhancement granted by the division bench of the High Court, despite the fact that the award of the tribunal was not challenged by the claimant, and held that the High Court wholly erred. 15.3, my lord, is Ranjana Prakash has been referred to. And then the finality is at page 72, 15.4, the last, my lord, but one page of this compilation. 15.4, my lord, considering the ratios laid down in the aforesaid decisions of Honorable Supreme Court, the division bench of this court in Sulekha accepted the position of law that an appellant cannot be worse off for filing an appeal should there be no cross objection there against, and the award of the claims tribunal attains finality on the claimant accepting the same without carrying it higher up. 15.5, in view of the proposition of law laid down by the Honorable Supreme Court in the aforesaid decision as well as the decision rendered by this court as above, it is needless to state that there cannot be enhancement of compensation amount in an appeal filed by the insurance company challenging the compensation granted by the learned tribunal in the absence of cross objection of the claimants. Lord, this is the final. For the reasons, my lord, so and so is not applicable. My lord, now, Lord, I place your lordship, my lord, 3 judgments. Division bench of this honorable court, not challenged. 2 separate single bench of this honorable court, all taking note of necessity, my lord, because those are all inbuilt, not challenged. And after these judgments, their lordships, even today, in absence of cross objection, are not enhancing the quantum. Even today. My lord, as I said earlier, my lord, I will not trouble your lordship with these Ranjana and Swaminathan, though they are a part of this. Lord. At the time of filing of this appeal, my lord, the only thing I would indicate on facts, there was no cross, amount was taken, and much after that, my lord, as an afterthought, my lord, this was filed. In the eye of law, it has been decided, my lord, the cross objection is not existing, my lord, it has been dismissed. On that basis and on these facts, my lord, my humble submission, my lord, would be that considering, my lord, this honorable courts, my lord, judgments which are, my lord, being followed even till this very day. And my lords, my lord, honorable brothers, my lord, have already decided this issue. No appeals preferred against them. They have all been accepted. It has not been taken to any higher court. No SLP, my lord, not to my knowledge, my lord. So today, your lordship, my lord, will kindly see to it, my lord, the line of judgments, what they are, my lord, they should be followed before your lordship, my lord. Because Penal 80, my lord, has already said in so many paragraphs, my lord, that my lord, even this judgment of Santosh, which was not in parlance with Sarla, and the judgment of Rajesh, which was not in parlance with Reshma Kumari, because as I said, my lord, one line of judgment was Sarla with Reshma, other was Santosh with Rajbir. Supreme Court said that, my lord, these are wrong. These are, my lord, this should not have been followed, because if you are not happy with your with the judgment of your similar bench, my lord, 3-3 or 2-2, then you should have referred the matter somewhere else. Why are you at variance? Taking note of those. This is not done, my lord. This is not good law. So, my lord, taking note of everything, but I humbly submit your lordship, my lord, kindly sitting, my lord, without cross objection, my lord, which is within time. Otherwise, my lord, no enhancement should be made.
Right.
I'm deeply obliged, your lordship. I conclude. But I was only for this.
Yes. Yes, Mr. Rai.
Lordship, actually, after speaking the lordship official mind, what shows that the lordship will decide the issue in favor of the claimants by considering the issue as decided with the Punashati, that the claimants are entitled to get the just compensation as defined by the Punashati is the dictum of the apex court, that all the court has to follow that how the compensation will be assessed. Undoubtedly, there is no ambiguity in this. I thankful to Mr. Singh. His judicial judgment has been placed before the lordship. All the judgment lordship will find there is no whisper whether order 4120 filed or not. Lordship kindly come from page 1 to rest. If lordship will find there is an application order 4120 filed and judgment delivered. Under what impression, what judicial expression law space, by considering the judgment of lordship Sudeep Juneja, while lordship found that the cross objection dismissed, that will be the technical issue, but it's been filed. Under the impression that has been filed, but on the technical issue, it's filed at later stage. So under such court, the just compensation in view of the judgment of Punashati under Article 141 of the Constitution also cannot be ignored. This is a very simple thing. Or lordship will direct me to explain or answer the queries as the judgment placed by Mr. Singh. One answer I have given, where lordship will not find not a single judgment in this compilation where the order 41 filed, even then order 41 order 4133 applied. My thesis is that I have filed an appeal cross objection. I filed an application in support of the consideration that application is the process will file in later stage. My humble submission. Lordship, can you condone the application for conversion of delay? Then interview goes. Because of after dismissed lordship judicial mind, before that I cannot say them. Because after dismissed lordship judicial mind, they are arguing. So at this stage, Lordship, can you condone this application for in connection with the cross objection? Because of already lordship given that advantage or the relief to the claimant in lordship judgment. So virtually I am supporting the lordship judgment. Why? So lordship also disclosed his lordship judicial view that the claimant is entitled to get the just compensation, even if it will be dismissed. So basically condone the application for conversion of delay because of lordship virtually condoned. Lordship virtually condoned. That's kind of mark it. Because unless and until lordship will condone, that will only come with the judicial mind consideration for consideration as life justice judgment of Sudhir. And lordship Vanjana Pukas, they have said. This is my main submission. So what the judgment passed by your lordship, that should be proper. And lordship is so kind, and lordship is so kind. Because of suppose lordship signed the order. Lordship, that is the lordship knows the civil procedure rules. The judges sign in the foot. It is not that the note that the when the judgment was delivered, that is the actual date of judgment. So lordship already delivered the judgment. The judgment virtually they're challenging before your lordship, which is challenged before the higher court. So can you pardon me? I am not Stanley. I have no. So they should have challenged before the higher court, beginning the dismiss the cross objection and award pass. But dismiss the cross objection, award pass by virtue of the Sudhir. But under what circumstances they are placing their bill in the future by grouping the case once again? Ranjana Pukas. Does you kindly see the Ranjana Pukas? What was the Ranjana Pukas? Yes, please rightly placed. Mr. Singh is very good. Please rightly placed the case. What is Ranjana Pukas? Claimant had not challenged the award of the tribunal on the ground that therefore they cannot find fault with it. As a consequence, the High Court ignored the error in the award of the tribunal. Let me kindly mark it. High Court ignored the error of the tribunal pointed out by the claimant, but only to note that error pointed by the insurer reduced compensation 30%. Only issue is that income tax 30% reduced. But what is the forum? If lordship will consider 4133 or lordship will not consider 14033, absolutely the lordship prerogative that have submitted in case of Mr. Bhumik also. Wherever there is no cross option.
Yes.
So absolutely lordship prerogative. It is not the prerogative of the Supreme Court also. If lordship will affect the discretion, then nobody will restore a lordship, even if there is a judgment of Justice Doctor. Lordship thinks that power has given by the statute, so I will use the statute. So the power as given by the statute, court will use the statute, which doesn't mean the other court will dictate this court how this court will function.
Yes.
It's true that if I not make cross objection for enhancement of award, that should be refused. But yes, by the judgment of Sulekha. Plus, if Sulekha, I have also played. I have said paragraph 10 and 11 is my submission. What was my submission before the judge? So the every case has a different perspective. What was my case? In default, the insurance will pay the award. Against that, I have made a submission before the Honorable Court. Lordship kindly see that the default clause, Lordship kindly regularize the interest. Moment Lordship was, did you file any cross objection? Once you have been refused. So once I have been refused by the tribunal, against that I ought to have filed a cross objection. There is no way. There is not that the order for is applicable on that issue. If I have been refused, that is R. Rangareti. Lordship knows the judgment of R. Rangareti, paragraph 20. But their lordship is defined where the order for 41 will apply, where the order for doesn't apply. Their lordship kindly see the R. Rangareti, lordship having with the copy. Lordship kindly see the paragraph 20. the illustration is given by the lordship. After dealt with the law, specifically dealt with the law, order 1433.
Yes.
Specifically dealt with the law. And after that, they are given a example. What is the example? The true relief claimed by the relief sought for by the claimant before the court of law. One has been granted, one has been refused. It was the one has been granted against the appeal paper. Other field did not file in cross objection. So they can ask relief under whatever rule 33, but they cannot get relief, which relief they have been already been refused by the. That is specific 20, paragraph 20, last 3 lines.
Yes.
So the compilation as placed by Mr. Singh, slightly placed. But also kindly see, is there any judgment in the compilation? It is not that tomorrow as when a lordship disclose the mind, then after they will come next day. Kindly, once lordship declares the judgment open court, the moment they will come, no lordship, I am sorry, I will come tomorrow, I will be very happy. That is not possible. But lordship, any judgment has annexed in that compilation that order 41 dismissed after that grant release in view of the judgment of Sundit Major, our High Court or Supreme Court discussed the view of the lordship High Court judgment. No, that should not be. After the judgment dated on 17th April 2023. Lordship knows the judgment. I have the various occasions placed this. And by virtue of placing the file,
Yes.
by virtue of lordship, the judgment is lordship in the file. By virtue of this judgment, there is a technical issue. It's mere just one word. The technical issue filed, but was belated stage. Why not? Because of under that impression, the appellate court has power of order 1433. They could have applied the power of order 1433 under that school, but the Honorable High Court dismissed the application of convention of delay in connection with the cross appeal, but that is mere technical issue. We found, just Supreme Court said, we found the just compensation has to be delivered because of to pass the complete justice. So lordship passed the complete justice. So lordship, I now next follow submission to put lordship against your lordship because the lordship judgment I'm not challenged against your lordship. Lordship also dismissed by application convention delay. I can prefer an appeal before the Supreme Court. The lordship was dismissed by convention delay. So lordship will allow that application. Suppose allow that application convention delay. Then what will happen? Then that figure will come. That figure will come. But lordship will doing the same to save the litigant. Once they are intending to get that amount by virtue of the punishity, or the just compensation already been decided by the fifth judge's bench. But lordship, why it is not my submission is that without cross objection, I will ask you the relief. But I can ask you the relief if that within the periphery or within the policy. Yeah, only kindly see that. Suppose lordship their judgment is awarded 15 lakhs, they were awarded. So their appeal goes. So 15 lakhs I am entitled. But lordship exactly the learned tribunal lump sum. Lordship can recollect that lump sum. That lump sum what they have also challenged. For that reason, at the instant on the last day I have submitted, lordship is required to consider my cross objection to decide the appeal of the appellant because of the lump sum that what they have also challenged without any complication, lump sum amount. Lordship, they have also the lump sum award. That the word lump sum, lordship also deleted that word in favor of the appellant. So no, the lump sum cannot be. If the amount will come by by considering the sound method, the multiplier method, If it will reduce, that was my submission. That's why I use the multiplier method, it's not method. If lordship will find that it will come reduce, if 15 lakh, more less than 50 lakh, pass that more less than 50 lakh. No problem. No problem. But why I'm asking? Because of the policy. Policy is the agreement. Policy permitted the award which are passed by lordship according to the policy. So whatever award, if the award beyond the policy, then I have to pay, make a separate suit, separate file, separate appeal. But that's within the policy. If they cannot say the insured, what the amount I have insured, what is the policy, what is the agreement, if third party got injury, then that is within the policy. That my submission is within the policy. It is not beyond that. I am not asking as a policy is limited policy. No, policy is said 1 lakh. You have been given 15,000, 3 lakhs. So you have to pay again because of, or the policy is limited is 1 lakh. So we already have given the 50,000. So we have to make that. No, my submission within the policy. Within the policy means just compensation. Just compensation. Why? There is the different views of the, we need the Supreme Court views are different. Supreme Court is several cases, Mr. Singh knows. I believe Mr. Singh will support me. Not only Rajesh versus Rajvi, 1,25,000. There is a judgment of the Supreme Court is given more than that. More than that.
Yes.
So the Supreme Court to harmonize the entire situation, come with the conclusion to all the pending cases is requested to the High Court to take the just compensation. And lordship in the entire judgment, lordship will find. Only the judgment will find out the just compensation. And this is not the case as high compilation as faced by the saying before your lordship. This is not the case where the lordship will dismiss the application cross objection awarded in view of the Supreme Court judgment. Had any judgment they have placed with that regard lordship?
Yes.
But it is the first time where the judgment passed by your lordship and the judgment challenged before your lordship and lordship passed the judgment. That is the first time. I don't know whether it's happened earlier. I don't know. So, what is the judgment passed by your lordship? I am deeply of the lordship. Lordship passed the just and just compensation in with the punishity as well as Punaja is right. It should not be interfered. Should not be interfered. I am deeply of the
Just one.
No lordship. জানি এটা হবে এটা আমি জানতাম এইটা যে হবে এটা আমি জানতাম not only that after passing the Mr. Singh further will come because of Mr. Singh our senior
It was my argument.
no it is not your argument please once
No, what you want to say? Just yes. What you want to say?
I am entitled to at least say something.
Yes.
Let one or two lines only. What I understand, is appeal of 2015. In 17, the money has been taken. And then in 22, one comes up with the cross objection and trying to take advantage of cross objection of 2022. This itself is an absurd, proposition. Number one. Number two, this Rangareddy said, I do not have that, but he said that, then, the prayer was made, a specific prayer was made before the court below for a specified amount or specified mode of calculation. That was not allowed.
already knows the case of compensation.
Whatever, that was not allowed. That because it was not forwarded to me. So it is not with me. I had given
that has been forwarded last day as well as argued Mrs. Paul with that one. That has been forwarded. That's it.
But it will be within the record. Yes.
I am not on. What is
Permission is going on.
it gets very difficult. It gets
No,
very difficult.
so what is your submission?
One line submission is not being the way it is being contested. Again, I said like yesterday. So this is not high court. The Reddy's judgment, the specific plea is being taken that specific prayer was made before the court below. That was disallowed. That is why this they came into this cross. In this case also, the specific prayer was made. A specific amount was claimed. A specific prayer was made with regard to the future prospect. Those were disallowed. And then still you chose to not to come. And there, my lord, I
For
respect.
the reason I
अरे यार,
have submitted
नहीं
before,
बोले
others he wrongly interpreted the wrong narrative. This is not because the wrong
No,
narrative.
okay, very well, very well. I have heard the matter.
And Lordship kindly consider order 222. So original affidavit withdrawn dismissed. The determined notice to the other party court. As the court makes things fit. That discretion is.
Yes,
there in
yes,
order.
I know, I know.
Lordship, I know.
I
Yes.
understand.
I'm bit clear.
Lord, your lordship is nodding my lord's head, my lord, but what is the, what my lord's nodded my lord's head like that. My lord, just now my lord nodded my lord's head like that. That something is wrong, my lord. My lord is searching out for some document.
Whether I am dictating the matter,
Lordship.
the seat was not there.
Oh.
Yes, that is why I am,
Lordship, I noted that on that.
all thing has been encouraged.
Can you on the calculation, can you note that?
And you also mentioned the 6,
Six.
can
Bawon,
6.
Bawon, and Lordship, the situation 9 lakhs something as Lordship.
Very well, very well, very well.
Also, can you note that on the computer?
I am passing the order letter.
Lordship.
Today, I am passing.
Lordship.
Call next matter.
I'm extremely obliged, your lordship, not for giving me this indulgence. my lord.
Also, I'm.
Yes. Mr. Bhattacharya.
My docket number 3 and 4, my lord.
Yes.
And I am for the respondent and appellant. There is 2 connected appeals. Your lordship, kindly take this up next week. I have to start with the copy of the application to the learned advocate for the insurance company. I am only praying for expunging the name of the respondent number 3 in respect of the appeal preferred by the insurance company. And so far, my appeal is concerned, Payal Manna's appeal. That appeal is that, but in that appeal also, the mother-in-law is also a pro forma respondent.
Respond number 2 or 4?
Mother 3.
This is an application for
Expunging the name of
expunging the name of respond number 4.
4, Mother.
Who is respond number 4?
Only respond number 4. You know, can you take it up Friday?
You served? Have you
Yes,
served?
madam.
Have you
No,
served?
madam, I have not
Okay,
served.
okay.
Can I take it up
Mr. Dawes?
Monday?
Please take down. The instant matter appear under the heading of to be mentioned. One application being can 3 of 2023 is filed on behalf of the claimant. Claimant is directed to serve the application of the insurance company.
Madam.
let the matter appear in the list on
Next Monday,
25th.
Monday. Not 25th, but next Monday, next week.
Next Monday week. Monday is the holiday, 2nd of October.
Third, my lord.
Okay,
Third.
third of October.
Grateful, my lord.
This is my application. My lord, it's a disposal matter. My lord. The disposal on 28th July by your lordship, my lord. And at the time of filing the appeal, my lord, the applicants herein, the respondent number 2 and 3 were minor. Man. When I filed the application for withdrawal petition, my lord, the department point out that unless
Have you
the
served?
my lord, in this matter, my lord, Mr. Pal is appearing, my lord, but
Have you served?
I have not served.
You
My
have to serve, otherwise how can I hear?
lord, in this matter, my lord, only take note the about my
Whatever
majority,
means
my lord.
You have to serve.
My lord, I have served. No, my
You serve, come on tomorrow?
lord.
Okay,
Just here and now, my lord.
okay. No order is clear. You serve and come on tomorrow.
My lord, I am good.
Not today. Yes.
My lord, day before yesterday, I started my argument. Since my learned friends were not Father Mukherjee. Yes. And another insurance company, Mr. Pali appears. Some of them were not absent. Lordship takes me, Lordship gave me opportunity to make, my lord, the submissions of complaints. The one may I reiterate for the actual matter. Yeah. And then the Dane tribe awarded $4 on 40.
Yes.
Other these activities things the award fast other things 160. That's the public that by the title. The minor suffered other to the extent of 92%. Other the top is both minor.
Date of accident?
Date of accident is 8 December 2003. That he was while he was in cycle minor, he was dashed by a minor under the luxury police past.
92% disability.
92% disability assessed by the medical board.
So, what was the award?
Award was Malad
What was your income?
income. Yes, Malad in support of his income. Malad first I would say that what is this Malad avocation? Malad is a
Self-employed.
Malad
General order supplier of bricks and
Malad supplier of bricks and chips from
rupees 8,000 per month.
in support of his income, Malad filed Malad other two SSB years income tax return. That was Malad accepted by the tribunal and Malad marked it as executed document.
Sorol for the year.
Yeah, 2000 Malad. Yes, sorrow for his 2004. 2003-4 and 2004-5.
For the year 2003 and 2004.
Now, my lord,
2004 and 2005.
2003 and 4 and 2004 and 5.
Yes.
My lord, as per the short form, his income shows about 90,000 or 91,000. Now, my lord, tribunal, my lord, assessing income without relying the income tax, my lord, the shown income 90,000 or 91,620.
What was assessed?
Assess is 50,000. Why? Because, my lord, since the schedule form, my lord, discloses that the income, source of income from agriculture is about 40,000 or odd. So, agriculture income should be, my lord, deducted. Only income is 91,000 minus 40,000, it comes 50,000. So 4,000 minus income per year,
Per month.
48,000, rounded 60,000 minus healthy taxes. That minus the assessment I have assessed. The first ground, the income of minus the income has not been properly assessed by the time. First ground. Second ground, other seat standard, the loss in standard, both standard carrying power and also speaking power. 92% also under 92% assessed by the medical board, but almost under 100%. I leave it to the Lord. 92% assessed by the
So tribunal has assessed to be rupees 50,000 per annum.
per annum and 92% disability has been assessed.
Very well.
But mother, there is no multiplier has been applied.
No multiplier adopted.
Multiplier mother, mother individual was dated about 28 years as per mother the Shadula Dharma on University. Multiplier would be applied 70.
17.
70.
What is the age?
Age is 28 years.
28 years.
And in between 25 to 30, the multiplier shown in the Shadula Dharma on the University is 70. So multiplier mother 70 but not applied, should be applied 70. Another date, the fourth ground is that the future proceedings. 40% is mother, is mother, the additional income on base of future proceedings. Yes.
Yes.
But here the mother, 40% future proceedings has not. What manner the assess under the tribunal, that is pain and suffering is 1 lakh and loss of amenities is only 1 lakh. That is, I also assess that is manner the person suffered 92% disability. My lord, while the victim, my lord, at the age of 28 years, my lord, giving my lord almost mother 60 70 years. Mother's AGT amount 1 lakh is not mother adequate. So I pay mother the pain and suffering. 1 lakh, I leave it to your lordship. Pain and sufferings and loss of amenities. 1 lakh, totally 2 lakhs mother I I pay mother more mother adequate compensation. This is the sum and substance of this matter, the accident and grounds of my appeal. Now, when the accident took place, whether the accident took place on 8 December 2003, on the same day, he was treated from the local manner is subdivisional hospital that I have annexed manner to Lordship seats. Manner the page 59 to 60. And he was admitted manner on the date of accident and discharged after manner 3. Page 59 to 60. Manner 40, page 59. Manner Prabhat. Mother actually Kumarman is the he was represented by his father Hon'ble or mom. His condition is such a way that he cannot mother will be able to come up to mother side or find his mother. Partition mother father also mother the modification also mother that person can be by environment.
Yes, yes, no issue.
Another page 59, your lordship kindly see. It was issued by the medical Mother the district hospital of Mother Hon'ble. Mother, here it appears he was admitted to the hospital on 10 December 2000. That is the date of accident. The mother duty was actually a multiple hearing
Head injury.
hearing injury and multiple the mother he was discharged on under the bottom line. He was discharged on 13 December 2000. So he remained in the hospital for about 2.5 days. Thereafter, he was retained before your lordship kindly come to page 72. The outdoor manner as a outdoor patients. That was 9 December 29 December 2003. Now the next page is page 73. That is further just after 1 month. That is 28th January and thereafter 9 2004. Mother was 5 and mother page 74. Mother that is on the first 1004. And mother bearer it was 6,000. Mother and the OP to patients in the food. Now, mother, dear lordship, kindly turn to page 78. That means the certificate issued by me by the Medipur Medical College and Medical Board of Medipur Medical College and Hospital. Mother, in column number 1, mother, it says that is a difficulty of and speech and hearing. Visible sponsor person. Here, he is physically mother, speech and hearing. Visible. Now, mother, column number 3, it says mother he is permanent is calculated at 90%. Here, mother, in the bottom, mother, there are the 4 doctors and also the superintendent of the medical college. Signatures also here. Now, mother, your lordship kindly turn to the Mala, the IT return and IT Mala, the total form. At page 650. The mark as page Mala 6. And the body total form page 650.
Yes.
The Mala, it was Mala. Finally, see on the top. Assessment year 2003, 2004. It was submitted within the time, that is in the bottom, it was 29 March 2004. His income has been shown in the left hand side at 19,400 and income tax payable 7,000. And is the statements of capital accounts of and the lordship kind and page 66, that will be 133.50. All of your lordship kindly done to page 16. Another minority showroom form of 2004-2005. It was filed just after manner 3 months. That is, for the auto, it was received by the Office of the Income Tax Department on 14 July 2004. And the income as shown in the manner left hand side is 91,620.
Very well.
Yes. Now, what the observations manner, tribunals manner has been. Lordship kindly start to the judgment page 29. Judgment page 4.
Yes.
Now, may I permitted to further. Let us approach. Let us approach to assess the amount of compensation awarded. It will be an interview on Dr. British Kumar Das, and he was attached to Mednapur Medical College and Hospital. He was a member of the medical board, and on that day, the was and a certificate regarding and the certificate that was not having. And after which reveals that the annual income of the work mark being 91,600, out of which 40,000 income. Being noted here that no material has come that after having work mark income has been, and in that event, they really carry income of the that is 4,000 and odd pharma. It is given from the certificate that the patient was in about 28 years of execution by the I propose that the pharma should be compensated. Out of which was 1 lakh for finance suffering and 1 lakh for property. There is no application of market system. There is no another application of mother guarantee. There is no applications of mother, the loss of earning and loss of earning capacity. And mother, the other heads of the mother, and non-liquid. Malad, I have calculated. Malad, this is my Samanta. W1 is the mother, the father. The mother.
Yes, sir. Let me hear about it.
Malad, before starting, Malad, I'll place Malad the assessment of compensation.
Let the income be assessed, then this.
No, it is here. Very, very.
তোমার কোনো রাইট
Yes. Please.
My lord, first of all, since I have not preferred an appeal, I would not say anything about the disability.
Yes.
It is only here speech and hearing disability 92%. Insurance company did not prefer an appeal because there was a lump sum amount given. My lord. Please come to page 29 of the paper book, my lord, judgment. Only. My lord, page 29, only let us approach to assess the amount of compensation to be awarded to the claimant. Petitioner examined one Dr. Prithvis Kumar Das, EFT surgeon. I have four. And he was attached to Midnapur Medical College and Hospital on 3204, and he was a member of medical board, and on that day the victim Prabhat Mal was examined by medical board, and a certificate regarding disability was issued to him, and the certificate reveals that Prabhat Mal was disabled, has disability to the extent of 92%, and it is also revealed that nature of disability was of speech and hearing.
Yes.
Only speech and hearing. My lord, we have to keep in mind the functional disability, only speech and here, my lord, please come later part of the judgment, my lord, in cross-examination, this deponent says that assessment of disability has been done on intuition, and after more, he has got no occasion to examine the patient. Petitioner has relied on Exhibit 6.1, that is income tax return, which reveals that the annual income of the injured Prabhat Mal being 91620, out of which rupees 40220 being his agricultural income. Be it noted here that no cogent material has come before this learned tribunal that after alleged disability of the injured Prabhat Mal, his agricultural income has been reduced. In that event, the yearly income of the injured may be deemed to 50,000, that is 4,000 per month. My lord, please come to the Saran, page 63.
Yes.
His yearly income, left side 90400, then income tax 7080. Then, my lord, see, less for agricultural income rebate 6960.
Yes.
So this business of chips and sand and cement, nowhere it appears. Next, my lord, page 68, Saran. 91620, income tax 7324, again rebate for agricultural income. So, my lord, the learned tribunal aptly said that there was no evidence that his agricultural income has reduced. That's why this 4,000 has been taken as his monthly income. So, my lord, my submission is, since it has not been computed according with the age and multiplier and all. This 4,000 may be taken as the monthly income and the computation may be done accordingly.
Please take down.
Yeah, I have bought market. And Mother, the income tax return is the Mother is the base document. Support.
No need.
No,
Thank you. The instant appeal has been preferred against the award dated 12th day of July 2006, passed by the learned judge, Motor Accident Claim Tribunal, 5th Court, Paschim Midnapur, in MAC case number 403 of 2004. So, the brief fact of the case is that the present appellant, being a claimant, preferred an application before the learned tribunal for getting compensation under section 166 of NDA on the ground that he sustained severe head injury due to rash and negligent driving of the driver of the offending vehicle duly insured under the policy of the insurance company. And by dint of such injury, he became hearing and speech disabled. So, the matter was contested by the insurance company before the learned tribunal. After hearing both the parties, the learned tribunal has awarded a lump sum amount of rupees 4 lakh, including the non-pecuniary damages of rupees 2 lakh. Stop. Being agreed by and being satisfied with the said award, the instant appeal has been preferred. It has been argued on behalf of the claimant applicant that the learned tribunal has wrongly assessed the compensation by fixing the income of the deceased income of the claimant to be 4,000 per month, abruptly 50,000 per annum. Stop. The income tax return has been submitted before the learned tribunal and they were duly proved by producing evidences. The learned tribunal has not considered the income tax return and passed the compensation erroneous. We also argued that the learned tribunal has not assessed the compensation on the basis of structure formula. Stop. We also prayed that the person has become permanently disabled of hearing and to speak. Thus, the award in favor of the claimant towards the non-pecuniary damages is not sufficient. So he prayed for just and proper compensation. Learned advocate for the insurance company submits that the assessment of disability by the doctor is erroneous. The person is disabled to speak and hear, so disabled for speech and hearing. So at this juncture, the disability cannot be assessed to be 92%. We further argued that the income of the claimant had been assessed justifiably by the learned tribunal in considering the sorrow form. Had the learned advocate peruse the materials on record, peruse the evidences placed in the paper book. In considering the income of the claimant, it appears to me that the claimant had submitted the documents regarding his income are certificate of enlistment and form of sorol filed to the income tax department for the assessment year 2003, 2004 and 2004, 2005. The certificate of enlistment was issued by the Mednipur municipality in favor of the appellant on 9th of March 2004. Stop. The sorol form, including the calculation of income and expenditure for the assessment, both the assessment year, were filed on 29th March of 2004 and 14th July 2004 respectively. Stop. All the documents appears to be prepared after the accident, that is after 10th of December 2003. The assessment of no document was filed by the claimant prior to the accident. Considering the same, it is not justified to place upon those documents to assess the just and proper compensation of this case. However, considering the fact that the learned tribunal has assessed the income of the claimant to be 50,000 per year, I think it is sufficient to determine. Stop. In considering the fact of this case that the that after the accident, the claimant was admitted to the Mednipur Medical College and Hospital in head injury, and due to such injury, he has lost his power of hearing and speak. The person obviously became a non-living person due to such disability. Considering the same, I think it necessary that the evidence of the doctor regarding the disability of the claimant need to be admitted. Stop. Next, in this case, the claimant is also entitled to get the future prospects according to the direction of the Honorable Apex Court passed in pronouncement. Stop.
And on the basis of that, I have also asked. Other I have feedback, what is that?
Thank you.
And give
Very. It would be full stop. It would be 40% to his established income. Stop. The next paragraph, the claimant was within the age group of 26 to 30 at the time of accident. So the applicable multiplier would be 17. Stop. In this case, the learned tribunal has awarded a sum of rupees 2 lakh towards the non-pecuniary damages. According to the direction of the Honorable Apex Court in past in R.D. Hathangadi, the instant appellant became totally disabled to perform his duties, and he is of tender age he was obtained arrest at the time of accident. So at this juncture, I think it necessary the non-pecuniary damage, the compensation towards the non-pecuniary damages would be 3 lakh instead of 2 lakh. Stop. In considering the same, it appears to me that in the award passed by the learned tribunal is neatly modified and recasted here as follows. It is
But it should be 13 lakh under 10,094 thereafter under lordship granting under total 3 lakh. So 10,94,800 plus 3 lakh income 30,94,800. And for 4 lakh has been murdered. So 30,94,800 minus 4 lakh comes murder
13 lakh
30,94,800
94,800 minus 4 lakh.
minus 4 lakh comes murder 9,94,000.
Stop. Yeah. The total award comes to rupees 13,94,800. Stop. The claimant has already received amount of rupees 4 lakh. So the balance amount comes to rupees 9,94,800. The insurance company is directed to pay the compensation along with 6% interest per annum from the date of filing of the claim application. That is from
Other date of filing is 28
8th May
28/5/2004.
from 28/5/2004. Stop. Within 8 weeks from the date of passing of this order with the office of the Learned Registrar General High Court, Calcutta. Yes. Okay. So New India students. The balance award comes to rupees. No, interest company. The New India Assurance Company Limited. Is that on such deposit, the claimant is at liberty to receive the same. What was your claim?
Claim was murdered 10 lakh.
10 lakh.
So it is within murder.
How is it?
No, 30 lakh. They said.
Very well.
So murdered
On such
arrest-
deposit, claimant is entitled to receive the same from the office of the Learned Registrar General High Court, Calcutta, according to the prevalent rules, subject to the ascertainment of payment of requisite court.
Balance 3,94,800. Murdered additional 49.
If you may,
And get
along with the certificate copies. Next.
Upon the appellate term, what is the proper term?
Yes.
My lord will remember that victim, he was traveling by the train and fell down and stuck up the leg. Case was dismissed by the tribunal
on the points, the Nana tribunal came into the conclusion that yes, he was a bona fide passenger. But even after that, as my lord, the tickets, the monthly ticket and the identity card provided by the railway authority were recovered from the body, which is mentioned in the inquest report. But in both the tickets and the identity card, though the identity card number is mentioned in the ticket, and both the ticket and identity card, both the ticket and identity card, the names of the victim was mentioned. The London Tribunal was of the opinion that since those were not signed by the person concerned, victim, and the rest was not there was no stamp, though it is a computer generated document, there was no stamp of the railway authority, so it was not genuine. Even the London Tribunal disbelieved the inquest report, disbelieved the evidence of eyewitness, and my lord, thereafter dismissed the case, stating that the person was not a bona fide person. Now, my lord, what I have stated earlier, what was the earlier occasion also, and my lord, one thing on this, on the last occasion, my lord asked that where is the inquest report, actual inquest report, and my lord, I have collected it. I have it was in my file, my lord, but so what I don't know why it was not annexed with the paper. But Surakhan report, page number 59. Surakhan report, page number 59. There everything is mentioned, but however, if my lord kindly permit me, then I have got this copy of inquest report. But may be permitted to file. Should be sharing. Yes, definitely. This particular inquest report, it is mentioned in the judgment. It was filed by the railway authority. It was filed in the railway authority by the railway authority, so it is their document, my lord. And my lord, since it is written, my lord, in such a way that it is not possible to read properly, I have also translated. It is online. I have written it properly. Yes, properly.
You hand over a copy.
Yes, my lord.
You hand over a copy to your opponent.
Yes.
And thereafter you give it to.
Yes, my lord. I am handing over the copy. Yes. Somehow, my lord, it is definitely, my lord, inadvertently, my lord, did not been able to incorporate it in the paper. But I have given the copy. And my lord, this is the original inquest report that was supplied by the railway authority, and I have written it in fresh way, my lord.
Read out.
আমি ইংরেজি 18/10/2004 সোমবার সময় রাত্রি 9:05 PM আমি এসআই মলয়কান্তি দত্ত সঙ্গে নম্বর 10581068 কৃষ্ণগুপ্ত শিয়ালদা জিআরপি থানা হইতে আগত দুইজন লোক যথা 1 শেখ কাসেম 2 ভোলা মিস্ত্রিকে সঙ্গে নিয়ে সোদপুর আগ্রপাড়া স্টেশনের মধ্যবর্তী জায়গায় 6 নম্বর রেলগেটের নিকট কেএম পোস্ট নম্বর 14/24 এর নিকট রওনা হইলাম এবং প্রায় 10:45 10:45 PM সময় উক্ত স্থানে পৌঁছলাম এবং পার্শ্ববর্তী স্বাক্ষরিত সাক্ষীগণের সামনে ডাউন 2 নম্বর এবং আপ 3 নম্বর লাইনের মাঝখানে পড়ে থাকা একজন প্রায় 36 বছর বয়স্ক পুরুষ মানুষের তদন্ত করতে লাগলাম। মৃত ব্যক্তির মাথা উত্তর দিকে, পা দক্ষিণ দিকে, ডান দিকে কাঁধে পড়ে আছে, গলার ডান দিকে আঘাতের চিহ্ন, ডান দিকে বুকের কাছে আঘাতে গর্ত হয়ে গেছে, মাথার ডান দিকে আঘাতের চিহ্ন, চোখ বোঝা, মাথার চুল কালো মাঝারি, গায়ের রং শ্যামবর্ণ, চেহারা মোটামুটি ভালো, পরনে ছোট ছোট বিভিন্ন রঙের চেক হাফ শার্ট, কালো হাফ প্যান্ট, কালো ফুল প্যান্ট। সাক্ষীগণের সামনে ডোমের সাহায্যে ভালো করে তল্লাশি করিয়া
তার পকেটে ডান পকেট থেকে আইডেন্টিটি ফটো সহ রেলওয়ে মান্থলি টিকিট পাওয়া গেল, যার নম্বর ডিস, ঠিকানা লেখা আছে মণি দেবনাথ, এমডি রোড, পোস্ট অফিস খোলা, বাজার, ভায়া সোদপুর, বয়স 36 বছর, নম্বর 5032 0776502, সোদপুর হতে শিয়ালদা, ভাড়া 100 টাকা, ভ্যালিড আপ টু 15 জানুয়ারি 2024। উক্ত টিকিটের জেরক্স কপি এই রিপোর্টের সাথে আইডেন্টি আটকাইয়া দিলাম। ভালো করে তদন্ত করিয়া মনে হইল যে উক্ত ব্যক্তি 3 নম্বর আপলাইনের কোন দ্রুতগামী ট্রেন থেকে পড়ে গেছে আর কি কোনো একই মত ব্যক্তি করতে পারে। পরীক্ষা নিরীক্ষা করে মনে হইল যে মৃত্যুর পিছনে কোনো দুরভিসন্ধি বা ফাউল প্লে নাই। তবুও মৃত্যুর সঠিক কারণ উদ্ঘাটনের জন্য মৃতদেহটি 106 রুমের সাহায্যে হেড অফ দ্য ডিপার্টমেন্ট ফরেন্সিক এন্ড স্টেট মেডিসিন এনআরটি হসপিটাল মর্গ এ প্রেরণ করিলাম পরীক্ষা নিরীক্ষার জন্য।
Yes.
So it is clear, my lord, from there, from the inquest report, that tickets were recovered. Ticket and identity card provided by the railway authority were recovered from the pocket, and he was a bona fide passenger. Now, my lord will recollect, my lord, that on the last occasion I identified this portion of the judgment. Bona fide admitted, my lord. One bona fide passenger was admitted. Page number 41, my lord. Page number 43. 43.
Yes, you have read out the judgment.
Yeah, I read it.
You have read out the judgment.
I was the opinion. The inquest report revealed that the body was properly checked with the help of room and identity card of this and railway month certificate from Kotu and 150 valid. The same thing. And in the circumstances, so after perusal of the ticket and after perusal of this inquest report, the larger tribunal was of the opinion that in the abstract I have the opinion that the appellant has been able to prove that this was a bona fide passenger.
Very.
Now, my lord.
Now we are out of time. So I have heard you, no issue. Only this thing I want.
Yes.
Very well. I have heard you, and when.
No, I want to give some judgments, my lord.
Told the other official 4-5 judgment.
4-5 judgments, my lord. Only 4-5 years. 4-5 judgments, 10.
Today you had the 10 minutes.
All right, my lord. Tomorrow, my lord. Stop.
Tomorrow faster.
Faster.
Quarter. Quarter tomorrow top. Second after which one? Acha, great petitions. Group 2. No.
Faster, second matter.
First up on top.
Top.
Pattern matter would appear on top.
Top, 5, 6, 7.
No, come on top. Very
dramatic game. And I am applying for the petition of matter. And for the respondent 3 to 6. 3 to 7. Well, it is the case, my lord, the petitioner is
Yes, I understand. What about the Union of India?
but one is for another judgment, my lord, Honorable Justice SUBHENDU Talukdar, my lord. And my lord, page 25 of my annexure, my lord. Annexure 4 P4.
No, what about the
25.
judgment? Why are you referring the judgment?
Yes, everything is
No, why are you referring this judgment?
because this is also just touch in my favor.
No, same issue was involved there.
Yes, or judgment, the Ashokta Shodhikari's judgment, my lord, following this, his judgment was passed. And on the Supreme Court judgment also, they are not.
No, only mere referring is not sufficient. What portion are you followed?
Everything, my lord, here that is the page 25 annexure P4, my lord. That is the everything.
Your petition.
Yeah, in my petition, my lord.
Page
Page 25, annexure P4.
Page 25.
Have you found my lord? Annexure P4, page 25. Here is dated, my lord. May simple introduction of pension and other capital benefits. Account of May simple. Here, my lord. And the signatures, my lord. 8-9 persons, my lord, sign these things, my lord. And that is the follow the West Bengal and other persons over to Dolly and other. Filed by the May employee was dismissed by the Honorable Court in their favor. And subsequent government of West Bengal Higher Education Department used such and such regarding confinement of non-teaching status of the postal made employee of the institute. It consists of the institute of the corporate meeting held resolution such and such. Committee was set up by office order such and such. Matter change of designation, including service matter of the next employee under the chairmanship of Professor A. Paul Dean Administration. After careful consideration matter and committee resolved the following. These companies employee considered as non-teaching employees of the institute and also execute for all the facilities as far above. Below such and such, release and retired means employed to be considered for pension or family pension, and the list of these employees who were in service from.
So you are for the family pension?
Yes, my lord. And her husband working up to 2001, my lord.
Date of retirement?
Date of birth 2001. That is a P1, my lord. P1. 31st July 2001.
July 2001.
P1, my lord. That is you are hereby informed that as per record of job, you are due to retire on 31st July 2001. The date of birth as per your declaration accepted by the office, that is 31st July 1941. You are requested to submit a formal application for payment of gratuity at any early date. This is the mother.
Very well. I understand.
So this is a good case for my lord, family as well.
What about the
last petition? Takes some instruction for the first point. 40.4. The person who was instructed the understanding of the conflict of petition my education, Minister of Education, has informed that you gather master report at the examination.
No, that ground cannot be entertained a read court. You know the issue, why you are stating like that?
From you, because the husband of the petitioner returned from service in the year of 2001.
Yes.
But the issue was transferred to IFPS, that is in the year of 2003. On the strength of the ECR Act, Act and the single LLC murder, 2014 murder. But I'm just putting in 5 years. Subsection section 5 of Amendment Act 2014.
Well, may I be permitted to copy my RAM?
Also,
Please.
The instructor,
No, this is
I get out the print out of the one copy. Just come and hand over
the read petition is pending since 2020 and you have not filed any affidavit.
On the order which is passed by IRP. Only from 2020 April, not before that.
So you whether you want to argue the matter or you file on pleadings or like that?
My lord, he took times, my lord, he took time, my lord. So, my lord, to dispose of this matter, this is a law of labor, my lord, this is.
Only thing that I cannot file affidavit of competition going on. Finish in this month. After that, I can file.
No, very well. You argue your matter.
That is my argument is only on the strength of my lord, section 5A, subsection D of SCR Act, Amendment Act 2014.
Yes. What is this?
Section 5A.
National Institute of Technology, Science and Education Research Act 2007. So what is 5A?
Section 5A of subsection B. Every person, including director, officer, and other employees, then on and after become an employee of Indian Science and Technology School and set hold hospital funding by the same tenure at the same remuneration and upon the same terms and conditions and the same rights and duties.
Yes.
As to pension, that committed for other matter, as to that made the same on the date of commencement of the National Institute of Science and Education Research Amendment Act, as if the state act had not been brought to court and shall continue until the employee is terminated or other what rights and privileges the particular employee was enjoying before 2014. That was not that privilege will not be entitled after the commencement of the act. after the commencement of this act, act, my lord, particularly after the amendment act 2014, my lord, the person who has retired from 13th of 2001 and the single injuring of crime correspond to IIPS in the year of 2015, and the act dated 2007. Thereafter, the amendment act which specifies stated section 5A, the petitioner shall not entitled to.
Why not? It is stated about the pension and everything. Read out.
Well, that is the what subsection 5A, that is subsection 2 of
And the privileges as to pension, leave, gratuity pension includes family pension.
pension at that point of time.
No, sir, in service,
2001,
they are entitled to get the pension.
no, they were not entitled to pension. It is well after the
Those are
ratio of
retired
transfer of
people,
IIPS.
they are not entitled to it.
And no,
Consider
approval was taken unless the cabinet also from the department.
Maybe. So this is your argument. This is only your argument. Yeah.
page 20, annexure B2, my lord. Page 20, annexure B2. Page 28, 2015. Without undertaking the government from Union Media, I will see memorandum, my lord.
This is the memorandum of Government of West Bengal, Higher Education Department.
Yes, thereafter kindly see up to 2000, those who are working, they will get the facility. My lord, kindly see, my lord, the consequent upon the introduction of uniform service condition and division salaries and allowances of the hostel mess employee attached to the hostel mess of state-aided university and government-aided college including Government Central Degree College and Government Engineering Technology College in West Bengal. While this department ordered number such and such, subsequent order in this regard, the governor is hereby pleased to direct as follows. The hotel mess employee of the state-rated university on West Bengal shall henceforth be treated as non-teaching employee of the respective university, and their salaries and allowances, including other service benefits, shall be the same as are available to the other non-teaching employee of the university. My lord, paragraph 4, my lord, kindly say, clearly stated, the hostel mess employee of the government aided college shall be eligible for the benefit of.
Yes, you have argued on the earlier day.
Say, so my lord, this is a genuine case, my lord. No, that is central government. And two decisions.
Access bar, that is the action from the central government.
Yes. What is your submission?
She repeats are the section for the matter. 76, we are structured. Fund is structured by it. And it is now an national guided by central.
You file affidavit by court.
Kindly, this is the judgment, madam.
After, without any affidavit, I cannot bind him. You file an affidavit by court.
After that, I can file it.
End of this month, I am 4th of October, I am still.
October, then take it on whether 8th or 10th, brother.
No, 8th or 10th.
Well, 2 March.
8th is the Sunday.
Then my lord, that is whether 10th.
Too late,
Within
my
10th,
lord.
that copy, conduct it.
If you can file on 10th, so you have to file on 6th. Come on, file on 6th, Friday. Last day of the week. 6th. Second up.
Second of perfect, my lord. Armin perfect.
9th, I would not be here. Come on, 6th. If you can file on 10th, then you can file on 6th.
6. Well, 6th October.
6th of October. Affidavit. Yes.
What I have been told by.
Notary affidavit has gone at the time of COVID. COVID gone, they also gone. So do you want any direction? So I can pass. Very good. Please take down. The matter is heard in part. The learned advocate appearing on behalf of the Union of India intend to file one action in opposition in respect of the petition filed by the petition. In respect of this petition, in respect of this read application. Stop. Considering the submission, the matter is adjourned to stop. The Union of India is directed to file an affidavit in opposition positively within 6th of October 2023. Stop. The affidavit must be shown by the undersecretary to the government of India. Stop. Let the matter be fixed on 6th of October at second half as a specially fixed matter. যাচ্ছি যাচ্ছি Yes. Okay, in this matter. But yeah, I was to find that we got and here we got BPS code. The national eligibility commitment says in Milan he had obtained certificate of disability that my lords may kindly come to page 37. This certificate of disability will also be used to find that Milad, the certificate of disability was issued on 22nd January 22. As my lord got it. Yes. 22nd January 20. Now, the feature of the disability which was mentioned here is serial number 14, chronic neurological condition. The serial number 14, chronic neurological condition in brain. Affected part of the body is the brain. Yes, I am grateful to. The extent of disability is 50%. That my lord was pleased. Now, your lordships may kindly consider that thereafter the authorities of IPG, MER and SSK, they had asked my client to appear before another board that my lords will be pleased to find in the next page at page 38. Yes. Now, curiously enough, your lordship will be pleased to find that in the earlier certificate of disability, there was indication of chronic neurological condition. Now, this time, the certificate of disability indicates that I am having locomotor disability. Kindly see. Locomotor disability. And 11%. Yes. And also, I find, subject to correction of my lords, that the locomotor disability is to the tune of 11%. Yes. Now, the board, the IPG, MER and SSK Miller, they conducted a medical test and Miller, they held
that I am not eligible for admission in the medical or dental course. Now, on the last occasion when this matter was taken up, my lord was pleased to observe that when there is a varying nature of a certificate of the disability, my lord was pleased to observe that your lordship will examine into the propriety of the action. Now, my lord, I submit to my lord very respectfully that the act which has been enacted, my lord, that I should hand up to my lords, my lord, the Rights of Persons with Disabilities of 2016. Just two provisions I will be just indicating to my lord. Kindly come to section 2R. Section 2, subsection R. Yes. Persons with benchmark disability means a person with not less than 40% of a specified disability, where specified disability has not been defined in a measurable term and includes a person with disability where specified disability has been defined in measurable term as certified by the certifying authority. Therefore, Miller, the minimum benchmark disability is it should not be less than 40% of a specified disability as it appears from the language of the section. Now, the other thing, Miller, which I will be showing to my lords, that Miller, your lordship may kindly consider also the specified disability that has been given under the definition of 2ZC. 2ZC. Specified disability means the disability as specified in the schedule. Now, Millard, under in this act, Millard, there is a schedule. Probably, Millard, this is 46 of the book, Millard, subject to correction, because my book will be varying with the page of bylaws. Page 46, Millard, is specified disability. Specified disability. Now, while Miller going through the brief, I was asking myself this question, that how the nature of disability that varies, because here there is an indication of chronic neurological condition in the certificate of disability issued by Bardhaman University at page 37. Kindly see. Then I will be taking to my lords, Millard, about the disabilities which have been mentioned in the specified disability schedule. Yes. Kindly see, in Bardhaman, chronic neurological condition, and my lords has already taken note of that this is in respect of IPGM here, this is locomotor disability. This my lords has taken. Now, my lords, kindly see the schedule. Locomotor disability, this is under physical disability in the schedule. A person's inability to execute activity as a movement of self and objects resulting from affliction of musculoskeletal or nervous system or both, including the leprosy cured person, then Miller cerebral palsy, dwarfism, muscular dystrophy, and acid attack victims. Kindly see the disability mentioned under the schedule insofar as chronic neurological conditions that has been indicated under paragraph 4 of the disability caused due to chronic neurological conditions. Yes. Now, here there is indication of multiple sclerosis, Parkinson's disease. Now, the nature of the physical disability as appears from the specified disability schedule the chronic neurological condition is not akin to the particular locomotor disability. This particular decision which was taken by the authority in respect of assessing my disability, in my very respectful submission, Millard, this is a faulty decision, or there is an error in the decision making process. Because rightness or wrongness of a decision, unless it is proved to be arbitrary, the court will normally not interfere or will not exercise its power of judicial review. But equally, if the decision making process is such that the court takes into consideration that this particular decision on the face of the record, it seems to be not proper, then Miller court will strike down to bring out an equity in the matter. Now, I was thinking the matter, Millard, in a greater perspective, that today I have obtained 2 certificates of disability. I appeared in the examination. The examination is over. Now, this, I am told by my learned junior, this is at the stage of counseling. Though Millard, my other side Millard, or my learned friend has taken a stand that already we have filled the seats. Therefore, we cannot give you any particular but. Millard, in my very respectful submission, supposing I particularly compete in a particular examination, I secure a but, there is a particular action, Millard, which by which I am aggrieved, I come up to the court. Now, the authority cannot non-suit my rights, on the ground of availability of vacancy, because I have to be given a particular admission in the particular course if the court finds that yes, there is a faulty decision making process. Now, the particular nature of the disabilities is a glaring instance, Millard, to indicate to my lords that this is particularly, Millard, not proper. My second respectful submission will be that, Millard, for an greater interest on Millard to iron out all creases, certainly, Millard, your lordship may kindly direct an independent medical body which my lord thinks proper, or whose particular credentials can be given, or can be greater credence can be given, supposing my lord the army hospital or any other hospital which my lord thinks, so that there is assessment of the disability insofar as the petitioner is concerned. If I have no particular right, or if I do not, Millard, fulfill the criteria which I have shown, that minimum benchmark has to be 40%, then I should be non-suited. I cannot be, Millard, given a but. But equally, the authorities cannot play fast and loose. One authority, that is also two. This is also the Bardhaman Medical College. Millard, this is also, Millard, a statutory body discharging statutory functions. And the particular IPG mayor is also, Millard, discharging statutory function. Therefore, there cannot be a marked difference in respect of the assessments made by the 2 particular bodies. Now, Millard, I should indicate to my lords Millard, that Millard, there is an order which was passed by Millard, a learned single judge. It starts from page 44 of the writ petition. Yes. That I can show to my lords, Millard, that the provisions of the Disability Act was brought to the attention of the court. Now, Millard, the observation starts It's from paragraph 11. No, Milord, I should start from para 10. Yes. Drawing the attention of this court to the provisions of the second proviso to section 34(1) of the PWD Act, Mr. Roy submits that issuance of guidelines and notifications setting the standard of eligibility for pursuing an MBBS course is permissible. Had there been no requirement towards specific eligibility rider, no expert committee could have been constituted and no notification to be issued to the debtor. It cannot be considered that the PWD Act refers to NCL from laying down suitable standards. Section 96 specifically provides that the provisions of the PWD Act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. He denies that the notification dated 13th of May 2019 would not apply to the present admission process. Mere participation in an admission process does not confer any vested right upon the petitioner, and even during the period of awaited from the date of commencement of the examination till the date of allotment of a seat, no right stands crystallized in favor of the candidates and they are bound by the rigors of the new notification. Record reveals that an interim order was passed in the present date petition on 25th of July 2020. Indisputably, the notice to conduct the enmity was issued on 29 November 2018. At that juncture, the MCI notification dated 22nd January 2018 was in operation. Results were declared on 5th of June 2019, and subsequent thereto, the petitioner was asked to appear before the medical board constituted in terms of the notification dated 4th of January 2018. The disability certificate was issued by the said medical board on 24th of June 2019 as per the notification dated 5th of February 2019, though by that time a new notification dated 13th of May 2019 had come into operation. The suitability riders as incorporated by the notification dated 13th of May 2019 were not in operation at the time of commencement of the admission process. The said process, which has commenced on and from 29 November 2018, ought to have been completed in accordance with law that stood at the time of initiation of the process. The selection process commences on the date of advertisement when the candidates are invited to apply. The notification dated 13th of May 2019 is prospective in nature, and there is nothing in the same showing any necessary intent for enforcing the same retrospectively. The petitioner admittedly comes within the purview of the definition of the benchmark disability as provided under Section 2R of the PWD Act. As regards mental illness, it has been internally been observed that the notification dated 13th of February 2019 that candidates are having disability equal to or more than 40% disability, or if the person is unfit to perform his duty, would be debarred from taking admission in MBBS course. With such rider, it has been stated that standards may be drafted for definition of fitness to practice medicine as are used by several institutions of countries other than India. Such riders appears to be tentative and no specific reason has been disclosed towards quantification of disability percentage and towards total exclusion of candidates with benchmark disability as defined under the PWD Act, and as such, the said riders in the amendment notifications are unreasonable and unlawful. It has been argued by Mr. Roy that the observations in the judgment delivered on 30th of April 2019 in the case of J. Vivin Supra pertaining to the amendment notification of 2019 are at best only obiter dicta in as much as the said notification was not under challenge. Obiter is a remark made or option expressed by the court in a decision upon a cause by way of an illustration, argument, analogy, or expression. Such observations are not directly on the question considered by the court and are made upon traveling into a territory without being invited. All the observations made in the judgment need to be read as a whole and not in isolation. A particular observation cannot be taken up and highlighted. In the case of J. Vivin Supra, the court was considering as to whether the suitability riders incorporated in amendment notification which came into force after commencement of the admission process can debar a candidate who fulfills the benchmark disability as provided under the PWD Act from admission in a course
under such reserve category and he or she had emerged to be successful in a competitive examination process. The said issue is inextricably bound with the issue of reasonability towards imposition of fresh eligibility riders by way of amendment notification, and as such, the argument of Mr. Roy that observations made by the court that the notifications are unfair, discriminatory, and unlawful are at best obiter dicta. It is not acceptable to this court. As a rule, the court is bound by the decision of all courts higher than itself. Judicial propriety also demands that the findings arrived at on the rudiments of similar facts and circumstances by another court should be given respect and should be followed. In view thereof, the court directs the respondents to grant admission to the petitioner in the MBBS course in the academic session 2019-20 in a state quota seat under PWD category 4. Now, Millard, this is one judgment which I have annexed in the writ petition. Yes. Now, Millard, my other limb of my submission is that the authorities, Millard, they will not suffer a prejudice or no injustice will be caused if there is a reassessment of the particular feasibility of the petitioner, because this is very confusing. I should say, Millard, not Millard, while I am addressing the court as a Millard silly advocate of the petitioner, I must say that if I am to judge a case in a fair and in an impartial manner, I should say that these contra findings which are staring at the face, this is very difficult for a particular court to come to a conclusion as to which is correct and which is not incorrect. Therefore, Millard, an assessment of the particular disability of the petitioner in any hospitals, Millard, which the court thinks that must be made, accepting these two authorities, Millard, wherefrom the assessment has been made. And thereafter, Millard, court may pass further orders about the action to be taken by the authority. Otherwise, supposing, Millard, if the particular thing is left to be done by an independent body, and by that time, Millard, this time will be passed, and a disabled candidate, he has, Millard, no sufficient means to, Millard, go into the niceties of the law and to avail of his remedies in a relentless manner. He cannot do, because at one point of time, Millard, he will stop saying that I cannot afford for it. Therefore, Millard, I appeal to my lords. Your lordship may kindly consider that the submissions made, that I lose my chance, I lose the bar, I cannot be accommodated. This I say, my lord, in my very respectful submission, this is not acceptable.
In the case of Ananda Maiti, the disability was 50%,
Yes,
and he was denied to the admission of medical college.
yes.
And your case is that uh, both the disability certificates are confusing.
The one disability is 50%,
And one
another
is 11.
disability is 11%.
11.
And in nature, and kindly see, which I have shown to my lord from the schedule,
One is locomotor and
yes, this cannot be, because my lord, it cannot be said that it may be, my lord, that I may have a disease. But if I am shown, my lord, that I have many diseases, that also sometimes becomes very faulty, because the main disability that remains. Apart from that, there may be detection of other disabilities. And my lord, my last submission will be,
no, whether petitioner has sit to a need, no.
my lord,
Whether he has appeared before the examination.
yes, he has appeared and his score, my lord, kindly see.
Okay, okay, okay.
Good.
NEET UG 21.
Page, my lord, your lordship may kindly see. Page 35 is the, I think, my lord, this is the admit card provisional, and page 36 is my marks which I have secured, my lord, in the national eligibility come entrance test. I have secured 159.
Yes.
And Miller, kindly also see the allotment of seat which was made. Page 40. Kindly consider these two documents, page 36 and page 40.
Very well.
And Millard, this is your lordship has taken note of it, that this is in connection with the national eligibility come entrance test of 2021. Now, Millard, this year, Millard, every year, Millard, this examination is being conducted. Now, having regard to the status of the disability, I cannot, Millard, even I cannot. I am not in a position to again Millard appear, because the same that there will be confronting Millard signals from the authority. This is number one. And secondly, your lordships may kindly consider that Millard and a division bench.
I think process of admission has been concluded in the year.
Yes, yes, and no, that conclusion, Millard, that stage of the earlier one, Millard, that Mr. Rai can appraise to my lords.
Yes.
Now, your lordships may kindly consider that there is another judgment of our court, which Millard is a division bench judgment. Chitor. 11th of April 2019. They are এখন এখানে by the
Yes.
These are, I think, Miller, I must not. These are my. One thing more. I add that if your lordship sees the nature of the prayers in the writ petition, that was at a stage when the writ petition was filed. But Miller, at this stage, Miller, the prayers can always be removed. Therefore, Miller, having regard to the nature or the facts of the case, my lord may kindly consider that Miller evaluation by an independent body, and thereafter Miller.
What purpose would be served?
Miller, I
At
lose
this
everything.
stage.
Absolutely. I say, Miller, kindly equally consider that today I appeared in an examination like guardianship examination or chief examination. I have a right to appear. Now I have a right to appear. Examination. Now, supposing Miller, I again, the answer was very, or the results of the test was very, utter failure of my entire career. Now today also if I appear, the same problem will come up. Unless the nature of the disability part is being resolved. Today also the same thing, because I have to again appear before the IPGM here. There will be two independent assessments. Maybe I have gone to Bardhaman College, I may go to Bakura College. There I may get a certificate of disability, but again this problem will come.
Yes.
Therefore, Miller, kindly consider that situation, Miller, a disabled candidate, whether his rights can be non-suited. And Miller, this act, which I had read over this act, Miller, the preamble of this act, of this right of persons with disabilities act, it does not say that you can non-suit the rights of a particular disabled candidate. If I am disabled, Miller, curiously, Miller, I say that one authority says that this is my extent of disability, other authority says that this is your extent of disability. One authority says this is the nature of your disability, another authority says that if I may say so, this is unsustainable. The entire decision-making process is erroneous and faulty and arbitrary. This is my respectful submission. Miller, I must not take the court's time, Miller. I have to, your lordships have given me
I understand.
very patient hearing. I am grateful to master.
Yes, Mr. Rai.
My respect to submission, greatest of respect to my loving senior friend. But today he has argued something which is not made out in this. Stand of the petitioner is something else. What my loving senior friend is arguing is something else. When I will see, I will have to place the documents once again. I don't want to waste your options time. That for I find out certain aspects of the matter. First one, time to take page 37. The disability certificate from Bardhaman Medical College and Hospital. But an affected part of the body is brain and limbs.
And limbs.
It's not brain only. Then Malad, the diagnosis I cannot read. According to the Bardhaman Medical College, it is 50%. Now Malad kindly turns over the page. Or I will take your lordship to what he is claiming. What is his disability that he is claiming? Kindly come to the pleadings. Malad, kindly take page 4 of the writ petition. Page 4.
Yes.
Malad, 1, 2, third paragraph. Kindly mark it. It is further stated that the petitioner has limb deformity, squat, pain during movement of back, and also personality problems. The petitioner has also delayed development of milestones which clearly point to cerebral palsy. Kindly mark limb deformity and cerebral palsy. This is his case. This is his disability. Now kindly come to page 38. Limb deformity and cerebral palsy. Now, under locomotor disability, what comes? Kindly see. Leprosy cured person, cerebral palsy, dwarfism, muscular such and such also. So the disability that he is claiming, that very disability has been assessed. It is not that why this stand is taken, because he did not get an entry model. But at this stage at which he could have said that this assessment is wrong and you have it done by a separate board, that stage has gone. It could have been done at the interim stage. He never made that prayer. What is the purpose today after 2 years when everything is closed, everything is finished? Why you did not make that prayer at the interim stage? You never got an interim order. So it is my humble submission that it is the very disability which he is claiming that has been considered. That's one. My second point is kindly see on the top. But this disability certificate is as per MCI guidelines.
Yes.
Now, kindly see after certificate number such and such, name of the designated disability center. That is the Institute of Postgraduate Medical Education and Research. This is the designated center for assessment of disability to get admission into a medical course. No other document is a valid document. You can get any certificate from any doctor, from any hospital in India saying that you have 100% disability. It is of no consequence. This is the disability certificate which is to be taken into consideration. Now kindly see who are the persons of the board. The last signatures your lordship will find Professor and HOD of Department of PMR IPGMER, Professor of Orthopedics, and Professor of Neurology. So even a neurologist was there and an orthopedic surgeon. Department heads were there to assess the disability of locomotor and cerebral palsy. There is no challenge that this authority is not the authority. There is no challenge in the regulation. Kindly see now the prayers. There is no challenge to this certificate. And now after 2 years, my learned senior friend says that your lordship will mold the relief. Kindly see the prayers. Issue a writ in the nature of mandamus to cancel the gazette notification dated 5th February and 14 May 2019. neither these notifications are annexed to the petition nor any submissions have been made. Therefore, I take it that this prayer is given. He has not argued this. To pass an interim order to admit the petitioner to MBBS course as soon as possible in the allotted college, such and such. Now, this prayer is redundant because the interim stage has gone. He did not get any interim order. Third is, pass an order directing the respondent authorities to produce the examination assessment roles of the PWD candidate. That is not required because we are not disputing the examination result. Yes, he has passed it and he has been given an allotment. And to pass an interim order to keep a seat vacant, but that order also has not been passed at the interim. So really, Malad, today, all the prayers of the writ petition have become infractions. First prayer is not pressed, the other prayers have become infractions. That's one. So no relief can be given at this stage. But of course, your lordship can modify it. But to what extent? One has to establish the right. Thereafter, your lordship will modify it. Now, today, Malad, the finding is that he has 11%, which is not under challenge. What is Ananya Maiti's order? My learned friend has relied upon. First point is Ananya Maiti's the order came within the time frame of that particular session.
Yes.
I will demonstrate it before your lordship. Petition was moved right on time, interim order was passed, thereafter final consideration and the court considered. Now what happened in that case? Why it is not applicable in this case? Ananya Maiti had a mental disability of 50%. It is above 40%. Therefore, Ananya Maiti under the RPWD Act was entitled to get a disability seat. Why she was not given? Because these notifications of the Medical Council of India say that mental disability is not considered for PWD category for medical admission. There the court found that no. Once it is established that somebody has disability above 50%, the RPWD Act comes into play. Whatever your notification you have to give. That's the reason why. Because kindly see, that is a candidate who particularly appeared before this board, IPGMER. May not have been the same doctors. In that year, there were different doctors, but the same institute, the same board. And that board gave Ananya Maiti 50% disability. That is why court said that no, once she gets a certificate of disability from the concerned authority of 50%, which is above benchmark disability, you cannot be barred. Fact is, we have preferred an appeal because according to us, mental disability cannot be a ground for, I cannot create doctors who have a mental disability for obvious reasons. Patients will suffer. So we have preferred an appeal, that appeal is still pending. But kindly see few lines and paragraphs of this judgment which my learned senior friend has placed. I take page 44 first.
Yes.
Kindly see the date of the order, 14th of August 2019.
Yes.
For 19, I will show your lordship the chart which is approved by the Supreme Court. 31st of August of every year is the cutoff date for admission to MBBS course. So for 2019, the cutoff date was 31st of August. This order was passed prior to 31st of August, when the admission process was in motion. Now, of course, 2021 admissions has closed. What are the dates? Everything I will tell you about. So my first point, so far as this Ananya Maiti order is concerned, is that it was within the cutoff date for admissions. Second, Malad, your lordship will kindly take page 2. Page 2, the first line. The petitioner appeared before the said medical board. That is this medical board, which is IPGMER.
Yes.
And upon examination, she was issued a disability certificate date on 24th June 2019, annexed at page 84 of the writ petition. In the same, the disability range was specified to be 50%. The petitioner was allotted a seat in the state quota under the PWD category at Calcutta National College, but when she quoted, she was denied admission as the disability certificate internally observed that not eligible for admission in medical schools. That is the reason why, because from IPG-MER she had a certificate of 50%. That's why court permitted. If this petitioner had a certificate from IPG-MER above 40%, he would have also got. That's the reason why court did not pass any interim order at that point of time. So the facts of this case and the facts of the petitioner's case are not similar. Malad. This does not cover the issue at all. Now, Malad, your lordship will kindly take, Malad, I don't want to, on facts, Malad, I do not want to waste your lordship's time. Kindly take two judgments of the Honorable Supreme Court where the position has been clarified. One other aspect, Malad, I should, in Hon'ble Maiti's judgment, Malad, there is a finding which has subsequently been overturned by the Honorable Supreme Court. I just place it, I will show your lordship, Malad, this part. Kindly take page 48.
Yes.
Yes, Malad, may I just read paragraph 12 once? This position has changed. Indisputedly, the notice to conduct the NEET was issued on 29 November 2018. At this juncture, the MCI notification dated 2018 was in operation. The results were declared on 5th June 2019 and subsequent thereto, the petitioner was asked to appear before the said medical board constituted in terms of the notification dated 4th January 2018. Disability certificate was issued. Kindly skip over the portion. The last line is important. The notification dated. The selection process commences on the date of advertisement when the candidates are invited to apply. Notification dated 13 May 2019 is prospective in nature and there is nothing in the same to show any necessary intendment for enforcing the same retrospectively. Now, Malad, this particular notification of 5th May 2019 came before the Honorable Supreme Court and a division bench of my Lord Justice Arun Mishra has held that the relevant date is the date of admission, because the candidates are required to produce their disability certificates at the time of admission. So therefore, your lordship has also found from the facts of Hon'ble Maiti that when she went to admission, then she was refused. Allotment was there because she filled up the form under PWD category. As per merit under PWD category, she got an allotment because everything is online.
Yes.
It is only when she went to get admission, then when she produced the certificate, and certificate says that you have mental disability, you cannot pursue an MBBS course, she was refused. So that interpreting that, the Honorable Supreme Court has said, I will place the judgment for your lordship, that the relevant date is the cutoff date. So when somebody is going to be admitted in August, whether the notification was given in January, whether the examination taken in May, result declared in June, these are not relevant. When you are taking admission, as on that day, that May notification is there, that is the relevant date to be considered and it will apply. But it is just because there is a proposition which was held and which was overturned by the Supreme Court. That's why I am placing it before your lordship. For our case, it may not be relevant because it is of 2019 and they do not dispute that it is not applicable, because this admission relates to 2021. Now, Malad, kindly take, this is the parent judgment where, Malad, the schedule of admissions have been indicated. Malad, this is reported in 2016, volume 11, Supreme Court cases 225. Volume 11, Supreme Court cases 225. Kindly take this, the case of Ashish Ranjan versus Union of India and others. Your lordship will straight away come to kindly come to page the internal page 1, the 4th page, Malad. Kindly come to the 4th page.
Yes.
It is the regulations of the Medical Council of India. Kindly see the charts. Kindly just above the chart, kindly see the time schedule for completion of admission process for first MBBS course. The lordship has found it. Now, Malad, conduct of examination such and such. 8, paragraph 8, the column 8 is relevant. Last date up to which students can be admitted joined against vacancies arising due to any reason is, Malad, 31st August. Kindly mark. Yes. I have already submitted while placing Ananda Maithi's order that it was passed prior to 31st of that particular day. Then your lordship will kindly turn over to the other, the entire, what the Supreme Court did was the entire regulation it considered what are the dates for various issues, graduate, postgraduate, such and such. Our relevant part is MBBS, so I have placed that. And kindly come to the last page. After taking into consideration all the schedules, last page, kindly see the first line. This court gives stamp of approval to the aforesaid schedule. So this schedule is approved by the Honorable Supreme. Yes. Then nothing remains and the part has been disposed of. So that's one. Now thereafter, relating to the admission of 2021, some seats were vacant. They went up to the Supreme Court that the date has passed, but we are unable to admit, and Supreme Court said that this cannot be done. This is reported in 2022 SCC online, SC, page 734. Number of matters were taken up. Kindly see. 730. Dr. Astha Goel et al. But I am not troubling your lordship with the entire judgment. I'll just come to the relevant. But can you take from paragraph 23 onwards? Yes. Applying the law laid down by this court in the aforesaid two decisions of the facts of the case on hand, and when the medical counseling committee and the Union of India have adhered to the time schedule for completing the admission process, and when the current admission session of NEET PG 2021, kindly see this is also related to 2021, is already behind time schedule, and even after conducting 8-9 rounds of counseling, some seats which are mainly non-clinical courses seats have remained vacant. And thereafter, when a conscious decision is taken by the Union government and the medical counseling committee not to conduct any further stray round of counseling, it cannot be said that the same is arbitrary. The decision of the Union government and the medical counseling committee not to have special round of stray round counseling is in the interest of medical education and public health. There cannot be any compromise with the merit and of the quality of medical education, which may ultimately affect the public health. The process of admission, and that too in the medical education, cannot be endless. It must end at a particular point of time. The time schedule has to be adhered to, otherwise ultimately it may affect the medical education and public health. Apart from the fact that after closure of the last round of counseling on 7/5/2022, the entire software mechanism has been closed and the security deposit is refunded to eligible candidates. It is to be noted that admission process for NEET 2022 has already begun. So this is also in our case, 23 has already begun. Yes. Therefore, it's any addition at the cost of repetition. Observe, so many seats are there, and for the above reasons stated above, the petitioners do not entitled to any relief. So, the consistent view of the Honorable Supreme Court is that it has to be done within the time schedule. It cannot be done beyond the time schedule. Now, the time schedule of 2021. This, of course, relates to this was a given in institutes was UG Council. This is the relevant part. But it ended on, kindly make a note, 15 November 2022. But this was an order passed in the Ashish Ranjan case, the 2016 parent judgment that I showed your lordship. Yes. But in that judgment, an IA was filed. But every year an IA is filed for the cut-off date. And there, your lordship kindly sees.
But I have only one copy. I have handed over to your lordship. Your lordship will kindly see, my lord. The order passed. What is the cutoff date is November
15th November 2020.
22. Because my lord, there was a delay for that year because of the pandemic. It could not be done within 31st of August. Supreme Court extended the time. There is no other authority who can extend the time. Supreme Court extended the time, and that is the order. That is the last date of admission. So, my lord, after this, there is no scope to admit the petition, even if the seat is vacant. Let us assume, my lord, there are physically disabled seats vacant. Even then, my lord, in 23, 21 candidate cannot be admitted. My lord, the law is, if I may say this, today, my lord, for every session there is a NEET examination every year.
Every year.
And there is a cutoff date within which it has to be completed. A candidate who has appeared in NEET 21 cannot have any right in NEET 23. And today, my lord, even if it is found that yes, he is a disabled, benchmark disabled category, let us assume, my lord, what my learned senior friend is praying, that let there be a board which will assess. Even if a board is constituted, and even if it is found that he is above 40%, he cannot get admission in this session. What he has to do is, on the basis of the certificate, he has to sit for the exam in 24 and then come and get it. It cannot be done because the clock cannot go back. If I admit somebody in 21, that person is to pass out in 25. If you put him in 23, 24, how will he pass out? So, Malad, these are my respectful submissions that it has really become infractions. And the second part also, your lordship will kindly consider, it is not his case that a wrong disability has been assessed. It is his specific case that I have a deformity of my limbs which leads to cerebral palsy. And accordingly, it has been assessed for locomotor with cerebral palsy. It has been assessed on that ground and on by a designated authority. It's not the authority who has found to have 60% disability is not the designated. And he has not challenged that this is not a designated authority or this certificate cannot be taken into consideration. That is not there neither in the prayers nor in the book. But these are my submissions.
Yes. Yes.
Sure.
If your lordship will not kindly takes not the act, the Right of Persons with Disabilities Act 2016. And what Mr. Rai has more or less covered everything. I just supplement few words, my lord. Kindly see, my lord, this act, my lord, this is 2016 Act, my lord. Your lordship will not kindly turns section 57. May I place, my lord, section 57? Has you also got it?
Yes.
Designation of certifying authorities.
Yes.
The appropriate authority shall designate persons having requisite qualifications and experience as certifying authorities who shall be competent to issue the certificate of disability. Subsection 2 says the appropriate government shall also notify the jurisdiction within which and the terms and conditions subject to which the certifying authority shall perform its certification functions. Now, my lord, on the basis of this 2016 Act, the Government of India will not issue a notification, the Gazette notification. Will not, if you also will not, this is not published on 4th of January 2018. But your lordship can skip first Hindi version is there, first 2 pages. Thereafter, your lordship get an English version. Ministry of Social Justice and Empowerment, and notification dated 4th of January 2018.
Yes.
Well, in this notification, your lordship would find, your lordship can see, the second paragraph from the bottom. It starts, my lord. And whereas the expert committee noted that the Ministry of Health and Family Welfare is the final authority to recommend the guideline on evolution and procedure for certification of the specified disabilities, and accordingly, the consolidated reports from all 8 subcommittees were referred to the Ministry of Health and Family Welfare for finalization. Now, my lord, kindly skip over the page, and next page you will also kindly turn, my lord, note 1. You will also find note 1.
Yes, got it.
In terms of section 57 of the Rights of Persons Disability Act 2016, the state government, or as the case may be union territories, administrators shall designate persons having requisite qualifications and experience as certifying authorities who shall be competent to issue certificate of disability, and also notify the jurisdiction within which and the terms and conditions subject to which the certifying authority shall perform its certifications functions. Now, my lord, on the basis of this, well, only 4 institutions throughout India have not the jurisdiction to issue this certificate. Well, kindly have a look at these 4 institutions named by the Supreme Court in this judgment. 2019-14 SCC 422. This is Puroshami Ashutosh minor through his father versus Union of India and others. Now, my lord, your lordship, my lord, state, my lord, comes, my lord, paragraph 14. At page, my lord, 426. 422. 1914 422. Now, my lord, your lordship would get, has also got it, my lord. Paragraph 14, my lord, at page 426.
Yes.
Now, my lord, here it is in respect of, my lord, NEET 2018. Now, my lord, in NEET 2018, there is a chapter, my lord, the same thing, same procedure is being followed. Well, these are the normal terms and conditions. Now, my lord, next page, page 427. Your lordship, my lord, kindly come, lord. Next page, page 427. Your lordship would find second paragraph. The candidates who consider themselves eligible for this category advised to ensure their eligibility by getting themselves examined at any government medical hospital, such and such and such. However, the candidates may kindly note that in case of selection under PH category, they will be required to produce a disability certificate from one of the disability assessment board constituted at the 4 metro cities mentioned below before their scheduled date of counseling. Now, first one is, my lord, that is Bardhaman Mahavir Medical College and Subjangpur Hospital, New Delhi, All India Institute of Physical Medicine and Rehabilitation, Haji Park, that is Mumbai. Next, my lord, here Kolkata, IPG MER. Next, my lord, Madras Medical College, Parktown, Chennai. So, my lord, these are the 4 institutions. Only on the basis of only these institutions have the jurisdiction to issue the disability certificate. So, my learned friend, the annexure, my lord, which disability certificate annexed by my learned senior friend, my lord, at page 37. This page 37, my lord, 50% disability, my lord, this certificate, my lord, at page 37 of this petition. This certificate, my lord, cannot be relied upon under any circumstances. And in this case, my lord, what my learned senior friend is proposing, that let there be an examination by any other institution. It cannot be, it can be done, my lord. It can be done only in respect of, suppose, my lord, had been, it was conducted by the SSK, my lord, IRP, MER. It can be conducted by other 3 institutions. But, my lord, the time is over. Now, my lord, this is, my lord, if your lordship can see this judgment, my lord, relates to, my lord, 2018-19, my lord, NEET. And, my lord, this judgment was delivered on 24th of August 2018. And, my lord, in this judgment, your lordship would find that there was a direction given by the Supreme Court. My lord, kindly see, my lord, page 420. Paragraph 18, my lord. May I please, my lord?
Yes.
Diverse orders were passed by this court from time to time. By an order dated 12/7/2018, this court noted the submission of MCI. An expert committee formed by MCI had opined that the persons with visual impairment of 40% or more could not be admitted to the undergraduate medical course, that is MBBS course. The said request was pending for consideration of the central government. This court, however, found that there were inconsistencies in the report, and accordingly called for expert opinion from a team of experts consisting of inter alia 3 senior members of ophthalmic department on the following aspects. Now, my lord, this order was passed saying the extent of disability percentage, if any, if yes, whether it is within the benchmark of Disability Act, whether the petitioner with the kind of disability, if any, he is suffering, is fit to undertake the MBBS course. So this was done, my lord, within that time. Now after the expiry of, my lord, 2 years, my lord, my learned friend, my lord, cannot make out a case from the bar. So, my lord, I am just supplementing with what I am adopting the submission of Mr. Rai, and I am just supplementing this, my lord. This is, my lord, absolutely, as on date, has become an academic issue. These are my suggestions.
Yes. Very. Sir, anything to reply?
Only one thing I would be indicating, that I was trying to find out in the writ petition whether any statement has been made with regard to the assessment made. That, my lord, I find in paragraph 5, page 5. Page 5, paragraph 5, kindly consider. Medical Board of IPGMER Hospital has wrongly assessed the assessment of the PWD candidate as because the PWD candidates are proper treatment in their Bardhaman Medical College and Hospital. Thereafter, authorities of the state Bardhaman Medical College and Hospital gave PWD certificate to your petition. This is the statement. And what was the submission which was sought to be made? By showing that I have made statement about my limb deficiencies, if this entire, my lord, paragraph 3 is being perused, my lord, I find, my lord, subject to correction of my lord's, my lord, that what is the state of affair that has been stated. These are my submissions.
But only paragraph 5 is wrongly assessed. Well, there is no specification as to the type or the percentage. This relates to the percentage. He has not said that the wrong type of assessment has been done.
Okay. Please take down. Matter harder length. Argument corporate made CAB.
Should I retain the book or
No.
we just? I'm
Take it,
grateful
take
to
it.
Grammar 60.
When did I appeal for the national body?
I appeal of the respondent. 1, 2, 3. Grateful to my lordship that allow me to file a affidavit in opposition and start that out with the time. Yes. Not this matter relating to promotion of the assistant teacher in the medical college, Kolani.
Yes.
All the time led by Mr. Shivankumar. I'm led by Mr. Shivankumar. This matter relating to promotion of a assistant professor, the medical college of Kullar. Notification was published for appointment for promotion. For promotion of this post, therefore we have applied for this post. Selection has been done. Thereafter, there is a eligibility. I have made an application before the register. Register did not consider our application. I came before your lordship. Came before this court. This court directed to the register to dispose of the matter after upon the hearing of the all the parties. My application was rejected by the after the interim order challenge hearing. Interim order case 42 is the subject matter of challenge. You can see the interim order.
Yes.
The issue is stateway Karachi. Whereas the eligibility criteria of the post of assistant professor was MD in physiology, and the last date of submission of the said application was 26/6/2008 at 4 p.m. This is the last date of submission of the application. My specific allegation at the date of the last date of application, the private examiner has no qualification for this post, for applying this post. Qualification required for MD. Who has got MD qualification? He only those candidates has applied for this. And then thereafter, and whereas the merit of the interview of the conduct to the purpose of the selection of to the said post, the West Bengal University of the Health Science, Salt Lake, Kolkata, such and such. We can take the next page. Next page. Whereas the contention of the board applicant in the Dr. Bhaskar Saha did not obtain the degree of MD physiology by the last date of submission of application, and such was not eligible to apply for the said post assistant professor. And whereas the Dr. Bhaskar has applied for the West Bengal University of Health Science, Salt Lake, Kolkata for acceptance of his application for through, he was waiting the final result of the MD course. Therefore, at the time of application, he has no qualification at all. The conclusion, the part. Now, therefore, after careful consideration of the entire facts and circumstances of this case, the transfers Dr. Bhaskar Saha was selected on merit on the basis of interview, where the applicant have been given equal chance to participate. Moreover, Dr. Jyotirmoy Vishwas and Dr. Arpan Kumar Ghosh, the applicant here, as well as that Dr. Bhaskar Saha were producing the MD course for the same academic session 2015 to 18. But from different university, Dr. Bhaskar Saha was allowed to apply for the said post on condition that he shall have to produce a final result of the MD course of the time of MD course at the time of the said interview. The university, in order to make the process of selection more democratic, board based, and the increase the talent pool for selection of the post allowed Dr. Bhaskar Saha, who is otherwise eligible in this respect. Then my application was rejected. But then come the notification first. The notification.
Page.
page 22. In the report. And what? Second point. Requirement, anatomy and physiology. Associate professor, assistant professor, assistant professor. 1 4. Name of minor case number. Competence. Page 23. Eligibility criteria. And
Yes.
what is- as per rules and regulation of the medical council of the medical council of or haven't do medical council. The eligibility criteria. Because it's a- and it's the competition high. Last. Assistant profession.
Yes.
Assistant profession. Academic qualification. Post graduate qualification in the EMS in the concerned subject as per the state regulation. Therefore, the MD qualification must be declared at the time of application. The last date of application. The last date of application is 26 June 2006. Sorry, 2008. My specific allegation. The private respondent has had no qualification at the material product time when the last date of application was over. Straight away come to their opposition. Opposition filed by the private respondent.
Yes. No, what is a prayer in the read application?
I was calling the respondent to show cause to why the selection of the private respondent and to seek promotion in the post of assistant professor in physiology by the order dated 4th October 2018. Mentioned in as a before in the requisition should not be set aside in the country. The written announcement responding the respondent to show cause to why the appropriate order dated such and such to the evening order. Commanding the third period, commanding the respondent to give appointment to the petitioner, the said post of assistant professor the physiology in place of private respondent.
And you also want to include yourself in the said place of.
Yes, and the eligible criteria on the material content and then.
No, okay, I understand. You just proceed. You are referring affidavit in opposition.
Yes. Page 29. That discrimination made by the private respondent to the register. Therefore, departmental promotion from demonstration of the assistant protection in Department of Physiology, College of the Medicine.
Yes.
So can you see that? Needs to inform you for your kind information that I, Dr. Bhaskar Shah, have been working as a demonstrator in the Department of Physiology, College of Medicine and GNM Hospital. Such from 1/12/2029 will get the 25 years. According to notification certain sir, I am applying for promotion from demonstration to assistant profession in the name department. So I can charge the department as well as the institute in a better way. My MD physiology, my MD physiology theory examination is over, and Viva principal practical examination will be held on 3rd and 4th July 2028. The date of application was 6 June 20. Hopefully, result will be published soon. Therefore, at the time of material point of time, he had no qualification at all to file an application for the promotion to the assistant professor, the post of assistant professor. He admits that he has not completed his MD qualification. Only theory is over, but the Viva will be held on certain subject. The last date of application was 26 June 2018.
What is the order on the challenge?
What's conducted by description is 42.
Page
42.
Page 42 of your read petition.
42.
Okay, this order.
Yes. As cited.
So your prayer was not considered.
My prayer is not because.
So this is the order dated 12th of February, 12th of December.
Yes, is the subject matter of check. The ratio is at the time of qualification, at the time of final application. If he had no qualification at all, then he is not eligible for this. I have several judgment, my lord. I have cited.
You have challenged 12th of order dated 12th of February.
Yes, 29.
This is the order 12th of February. Okay, 12th of February.
Yes.
But where is the order dated 4th of October?
Second to page 28. It's a notification. Page 29. Column 7. In persons of the persons of the approval of the competent authority is the promotion. University of Health Science, Dr. Bhaskar Saha, now working as a demonstrator, and ANM Hospital, Tulani, India, thereby promoted to the post of assistant professor in the existing vacancy. Just say. Okay. I'm
May I retake?
Yes. This will be the last one.
Get put.
Other all matters are ready.
Yes. Mark up.
Yes.
The main point has cropped up. The eligibility criteria of a candidate has to be determined on which date. Because you'll also see my junior has stated that the advertisement was published on 11th February. Last date was given 26th February. Number of the June. Now the eligibility criteria, that is my lord, MD in physiology. Now joining date also, the private respondent has joined later on, whereas my joining is before that. Now my lord, they have admitted in the application, in the affidavits, that they have prayed for that they will produce the mark sheet of the MD at the time of interview. They have admitted that, and also the university has also admitted that. Therefore, when the eligibility criteria has been determined, that you have to file an application by 26 June, on that day, you have to fulfill the eligibility criteria. Otherwise, you are not eligible, because on that date, you are not eligible at all. Because on that date, you are not eligible at all. The guideline also provides what is the eligibility criteria? MD in physiology. Because this is the promotional post, demonstrator to assistant professor. Therefore, if you do not fulfill the criteria, then you are not also eligible to make an application. And to that extent, Supreme Court has given so many judgments. I am starting from judgment, the Rekha Chaudhary case. 93, Supply 3 SEC, page 168. 93, volume 2, Supply 3 SEC, page 168. Paragraph 11. No, paragraph 11. Where the Supreme Court has clearly held the candidate, I am reading the the candidate selected must be qualified as on the last date for making application for the post in question, or on the date to be specially mentioned in the advertisement. Here the advertisement published in the mentioned, you have to make an application by 26th. The qualification acquired by the candidate after the said date should not be taken into account of consideration. I am saying these words. Therefore, you have obtained this qualification after the date is over. Therefore, on that date, you are not eligible to make an application. If you obtain this qualification after the date is over, that qualification should not be taken into account by the committee. But kindly see, objection. 2011-12 basis है देखिए state of the art তোমাকে যে একজন আছে থেকে নিয়ে আসুন রাজবেন কোথায় কি কথা state of the art বের হবে বাস মধুরানি
You are referring paragraph 11?
Yes. Rakesh Sumaj. Another judgment I am citing. State of the Kindly see paragraph 6. State of Bihar versus Madhukant Ranjan and another.
Para 6.
Para 6. At the outset, it is to be noted that as per the advertisement, the applicants were required to submit the photocopies of all relevant documents, public certificates, along with the application form, and the originals were required to be produced at the time of their appointment before the selection council. It appears that the original lead petitioner did not produce or submit the copy of the NCCB certificate, can you mark it? NCCB certificate along with the original application. Therefore, in absence of submission of the photocopy of the NCCB certificate along with the application, he has not allotted 5 marks of the NCCB certificate. However, he submitted the same in the year 2007 after the physical test. Therefore, he filed a petition being such and such number making a grievance that he has produced the certificate NCCB. He had been wrongly awarded 12 marks and denied the 5 additional marks. The learned single judge of the High Court refused to issue any positive direction by observing that there is no pleadings in the petition in support of the claim that he has annexed the NCCB certificate along with the original application form. The learned single judge also observed that from the pleadings it appears that he has submitted the same after the physical test on 15 January 2007. That means before the results were published on 26 December 2007. Observing so, the learned single judge held that in the absence of the necessary pleadings, the petitioner annexed his NCCB certificate along with the original application. The court finds it difficult to issue any positive direction with regard to the consideration of his candidature. The order passed by the Lingge Sanjay is such and such. This is the order of the single judge. But I am skipping it over. Now kindly see paragraph 7. That as per the pleadings in the earlier petition, such and such, there was no awardment in support of his claim that he has annexed the NCCB certificate along with the original application. However, when subsequently the present petition was filed, the original petitioner came out with a contrary stand that he has produced all necessary documents, including the NCCB certificate, along with his original application. The aforesaid is nothing but an afterthought, having failed to get any positive direction in the earlier petition on the ground that there is no pleading that he had annexed his NCCB certificate along with the original application. He is not entitled to any positive direction and therefore original writ petitioner cannot be permitted to improve his case in the subsequent litigation when it was not his case in the earlier writ petition. At the cost of the repetition, it is to be observed that in the earlier round of litigation, the learned senior specifically observed that there is no pleading in the writ petition, and the petitioner annexed the NCCB certificate along with the original application. Once it is found that the respondent number 1 original writ petitioner did not submit the photocopy of the NCCB certificate along with the original application, which was the requirement as per the advertisement. I did note that advertisement, and the cutoff date as per the advertisement was 22nd February 2004, and he produced the same after the physical test is over, that is on 15th January 2007. The appointing authority rightly held that he shall not be entitled to additional 5 marks, and he was awarded 17 marks, which included the 5 additional marks. The appointing authority disagreed with the same on the ground that they had the photocopy of the NCCB certificate was not produced along with the application form, which was the requirement as per the advertisement. He shall not be entitled to any 5 marks of the NCCB certificate. Therefore, when a decision was taken on the representation made by the original writ petitioner, which was pursuant to the earlier order passed by the learned single judge in the writ petition, the authority rightly refused to allot the 5 marks towards the NCCB certificate. As per the settled provision of law, a candidate of the appellant has to comply with the condition eligibility criteria as per the advertisement before the cut-off date mentioned therein, unless extended by the recruiting authority, and only also those documents which are submitted along with the application form, which are required to be submitted as per the advertisement, have to be considered. Therefore, I am standing on that footing, because you have to file all these documents along with the application as per the advertisement. You cannot have any right to produce any document after the cut-off date is over. Now, my lord, the second judgment, my lord, Himachal Pradesh versus State of Electricity Board. There are 10, 11, and 12. There are 9, 10, 11, 12. The same view. This court in the Ashok Kumar Sonkar versus Union of India reported 2007 for SEC 54, and in this case Rakesh Kumar Sharma versus State and others reported in 2013 11 SEC has held that cut-off date for acquiring the qualification advertised in the last year of application. When I am not reading further judgment, all are the same principle. Now, my lord, the another judgment I will 2011 12 basis, I think. 2011 12 basis. On the 2011 12 basis, page 85, para 29. Here the Supreme Court has said, I am reading the judgment, thereby I am handing over to your lordships. Said, we have considered the entire matter. In our opinion, it is too well settled to need any further details than that. All the appointments to public office have to be made in conformity with the Article 14 of the Constitution of India. In other words, there must be no arbitrariness resulting from any undue favor. Kindly see, resulting from an undue favor being shown to any candidate. Therefore, the selection process has to be conducted strictly in accordance with the stipulated selection procedure. Consequently, when a particular schedule is mentioned in an advertisement, the same has to be scrupulously maintained. There cannot be any relaxation in terms of the condition of the advertisement, unless such power is specially reserved. Such a power could be reserved in the relevant statutory rules. Even if the power relaxation provided in the rule, it must be still mentioned in the advertisement. In absence of such power in the rule, it could be still be provided in the advertisement. However, the power of relaxation if exercised has to give due publicity. This would be necessary to ensure that those candidates who become eligible due to the relaxation are afforded an equal opportunity to apply and complete the relaxation of any condition in advertisement without due publication would become contrary to the mandate of equality contained Article 46 of the Constitution of India. Therefore, you have given relaxation. You will produce the mark sheet at the time of interview. What power you have given? You have been given. What power? The rules does not provide so. Because the cut-off date is there, advertisement is there. When a private respondent has made an application, I will produce my mark sheet of MD at the time of interview. And you have considered it. You have given the opportunity. Yes, you produce the mark sheet at the time of interview. Who has given the power authority? Under the rules, there is no. Therefore, relaxation of power you have given, this power has not been mentioned in the rules. So on which basis you relax the rules? This is Supreme question. You cannot give any undue favor to any candidate because the selection procedure has to be maintained as per the rules. Since the private respondent, you have given an undue favor because you will because at the time when the result was published on 31st July, 21st July. The result was published on 21st July. Date of interview 31st July. Now the date of cut-off application 26 June. And he had admitted when the interview day was fixed, his examination is not completed. His examination is completed first week of July. Therefore, on that day, he is also not eligible at all. And the date of result was published 21st July and interview date 31st July, he has produced the mark sheet. Therefore, on the very cut-off day, he did not, his examination is going on, even he did not eligible. That's why Supreme Court said, kindly see 29, 30, 31, 32. '97 volume 4 is the (2039). Yes. Now, in 1993, in Ashok Kumar Sharma case, now the Supreme Court held that at the time of interview, the documents can be placed. Now, that case, a review application was filed in Ashok Kumar Sharma case. That review came up in 1997. Then the review, Supreme Court has held, no, this issue is a wrong issue. There, Supreme Court has held the proposition that where the applicant are called for prescribing a particular date as the last date for filing application, the eligibility of the candidate shall have to be judged with reference to that date, and that date alone is well established one. Therefore, on that particular date, the eligibility criteria has to be established. This is, my lord, Ashok Kumar Sharma review judgment, 1997, volume 4, SEC, page 18, paragraph 6. Do I 30? Yes. Normally, in Rakesh Sharma's case, 2013-11 SCC, page 85, sorry, page 58. Now, kindly see paragraph 11. Exercise. Paragraph 11. I have given red mark. Kindly see. Volume 4. One. বলে দিচ্ছি তোমার কোনটা চ্যানেল বলে শুরু করছো চ্যানেল হলো হবে না তুমি শুরু করছো কোথাও শুরু করছো রিজার্ভ
Yes.
লেভেল দেখেছো রিজার্ভ দেখেছো এটা Now, the notification which was published by the West Bengal University of Health Science, this is one for stitch, page 22 of my read petitions. I'll show to your lordships.
Yes, got it.
And can you see the physiology? As you lordship got it. Physiology. As you lordship got it. Now, the can you see associate professor 1?
Professor, associate professor, assistant, all are one.
Yes. Not assistant professor. And assistant professor also 1. Within bracket R, R meaning thereby, can you see bottom, R means resulted vacancy.
Yes.
Now, your lordship has seen the order which was passed by the authority, which is the subject matter of challenge. They have also admitted in the order that, my lord, the can you see this order? Page 42. They have admitted. Page 42.
Yes.
Well, can you see page 43? Well, I am not reading the earlier order. Page 43. Page 43. Second paragraph. Whereas the contents of both the application is that Dr. Bhaskar Saha did not obtain the degree of MD Physiology by the last date of submission of the application, and as such was not eligible to apply for the said post of assistant professor. And whereas Dr. Bhaskar Saha has prayed, kindly note that, has prayed to the West Bengal University of Health Science, Salt Lake, Kolkata, for acceptance of his application form through you are though you are waiting the final result of the FD. Kindly note that. That is the admission fact. At the time of application, he was waiting for the result of the MD. That he does not possess the degree of the MD at the time of making the application, that is on 26 June 2018. Now, therefore, kindly see. After careful consideration of the entire facts and circumstances of this case, it has transpired that Dr. Bhaskar Saha was selected on merit on the basis of the interview, that the applicants have been given equal chance to participate. Moreover, Dr. Jyotirmoy Biswas and Dr. Arpan Kumar Ghosh as well as Dr. Bhaskar Saha were taking the MD course for the same academic session, but from different university. Dr. Bhaskar Saha was allowed to apply for the said course on condition that he shall have to produce the final result of MD course at the time of interview. What authority has been given to the? So you will produce the marks at the time of interview. When the cut-off date is over, Supreme Court has said clearly that your eligibility has to be determined on the date of the application. And under which provision you have allowed him to produce the mark sheet? What authority you have got? And in the advertisement, it has been mentioned that the aspiring candidate will have to produce the marks sheet at the time of interview. There is no whisper to that extent. Then there are other candidates who can also make an application. They have been debarred. Article 16 has to be protected. Equal opportunity. So why you did not mention this application in the advertisement? Those candidates who did not have the qualification at the time of the application, he will produce the mark sheet at the time of interview. The other candidates are standing on the queue. They have been debarred. You cannot do that by exercising arbitrary power. And you are given an undue advantage to a special person, who is your choiceable person. And recruitment has to be followed impartially, not partially. And I am the candidate who has joined earlier. I am possessed the degree. I am debarred. As Supreme Court has said that you have given an undue advantage to this candidate to be employed for giving appointment.
You had the qualified degree, MD,
Yes,
at the time of
making application. My lord, MD degree has been published.
26 before 26 June.
Yes. Yes. But
Have you pleaded?
yes, it has been pleaded. Paragraph 9 in my petition. 14 June 2018. And that's last date of application 26 June 2018.
Yes. Proceed.
And therefore, I have got this eligibility criteria. I have joined earlier as a demonstrator. He has joined later on. He did not have the eligibility criteria on the date of last date, cut-off date. But the authority allowed him, you produce your mark sheet at the time of the interview. That is totally beyond the rules, and that was not also mentioned in the advertisement. Therefore, you cannot do that. And Supreme Court has specifically clearly stated that eligibility criteria when it has to be determined. After the acquiring of the qualification of the cut-off date, your qualification cannot be taken into consideration. This is the ratio of Supreme Court judgment. In all these judgments, I put rulers. whatever the qualification you have possessed at the time of making application, that is cut-off date, that is to be counted. Not after that.
Yes.
And therefore, my lord, his appointment, that is the private respondent appointment, is totally illegal appointment, and that is to be liable to be set aside. Entire appointment is, my lord, totally by way of giving an undue advantage to that candidate, totally beyond the recruitment rules and beyond the scope of the advertisement, and all this action of the authority is arbitrary and against the principle of the Supreme Court judgment. This is my submission. Yes. Wait a minute. What are we?
Come on, next, what is it?
I am the main answering respondent 1 to 3. It's a university.
Number 4, private respondent.
And these books, these books I will give a photocopy.
Photocopy. Give me the photocopy.
Yes, I will.
Please take down.
What are we doing?
The argument on behalf of the petitioner concludes. Let the matter be made parted.
Next one. Next one is
Next one. Only one. As a first matter.
Yes.
To appear as a first matter.
Yes, yes.
Practically direct the petitioner. Give me a fresh copy of the application from 19 to 25. Middle pages are not there. In my service copy.
I will do that. I will do that.
No order.
No. What about the 19 থেকে 25 তো
Matter be fixed
ওদি
on
19 থেকে 25 তো 19 থেকে 25 তো
19 to 25
27th of September 2023 at 2 p.m. as a specially fixed matter on top.
পাঠা করে দিন
My lord, I have only one prayer. Item number 74, my lord. Kindly take it on next Wednesday. Otherwise, your petitioner is suffering serious problem, my lord.
74.
74. Top of the list as hearing matter. My lord, kindly take it.
Very well. Please take down. Item number 74. Be appear within the 5 matter, the top of the list on 27th of September.